Upon notice?
Yes. Yes.
Have you seen the first page of my list? Please read the first page and come back.
Lord, may I be permitted to mention one contempt application, my lord, for modification to the effect, my lord will recall that Chut plot, my lord, Noyenjuli matter, my lord. In that, my lord, on the last occasion, my lord passed an order, my lord, that the NHAI authority, my lord, has been ready, my lord, to comply the order, and my lord, in principle, my lord, they have approved a certain sum of money. Now, my lord, the NHAI authority has contacted, my lord, the petitioner. My lord, the difficulty is that, my lord, in that place, my lord, the LA collector has already determined that portion as Noyanjuli. Now, my lord, the National Highway authorities, my lord, has categorically said, my lord, that we want to we will acquire the entire land, my lord, and pay compensation for the entire land at the present value, because since the acquisition is taking place now. My lord, in that respect, my lord, only two, my lord, observation is required, my lord, since, my lord, that Noyanjuli is there, my lord, that has to, my lord, go, because now NHA has already...
Do you have to ask for modification of the main order, the principal order?
My lord, the principal order is not required, because the subsequent, my lord, it was a development, my lord, that has been set at Noyanjuli. My lord, the order was passed to pay compensation. That was
Have
the
you
main
made
order.
an application to that effect?
No, my lord. Why, my lord? The main order was that to pay compensation. That after that, my lord, assessment has made taking that step as Noyanjuli.
Why don't you file a supplementary affidavit and stating all these facts?
My lord, because
these are subsequent developments.
Yes, because since, my lord, this order has been passed, my lord, after that, my lord only passed that order that they have agreed to pay. My lord, this complexity, my lord, somehow, my lord, is a 80-year-old, my lord, again application, my lord, then, my lord, that's why, my lord, only I have given
Have you
notice,
put the other side on notice?
Yes, my lord, Mr. Shingora is already there.
My lord, may I be allowed
Contempt application.
my lord?
Notice niche.
So you have seen the first page of my list. I'm not taking up mentionings now. Only restorations, contempt, and corrections.
My lord, extension of interim order, my lord.
Upon notice?
Yes, my lord. Grateful, my lord.
But you are saying it's running in the list. Have you put the other side on notice? Please put the other side on notice and come back.
Lord, yeah. This matter will come tomorrow or day after.
Let me see. Let me see.
Deeply obliged, my lord.
Yes, call the days list, please.
For the petition, my lord.
I am appearing for respondent number 5 and 6.
For the state,
You are the petitioner?
my lord. Petitioner is not willing to move the instruction.
Learned counsel for the petitioner submits that the petitioner does not intend to proceed with the writ petition any further. Paragraph written instruction submitted by the petitioner is taken on record. The paragraph in view of the above, the writ petition being WPS such and such is dismissed for non-prosecution. There shall, however, be no arrest to costs as in certified website.
ঠিক আছে আমারটা দিন তাহলে আমারটাই দিয়ে রাখুন সমিত্র দা এগুলো তখন হ্যাঁ নামটা দিন আমার মনে থাকবে না আমার মনে থাকবে
Yes.
As per your lordship direction, I have served the copy of the content
It's
application to my learned senior friend.
some time my lord because my lord
The lordship, this is the letter, lordship, issued by the executive engineer who is the alleged contemner to the another executive engineer Alipur division seeking instruction that regarding the details of the land. And also this letter also forwarded to me personally to the learned advocate. Now, lordship, this in terms of this letter, I immediately forwarded the copy of the writ petition, and this is the my letter. Also, kindly observe this and direct.
Learned counsel say, Mr. Dey says,
Yes,
we comply with it.
yes ma'am I must comply with it.
And they are in the process of compliance,
Yes.
isn't it?
Also, subsequent development, I am praying for let this be recorded in this order. Subsequent development.
You want me to keep this in record? Shall I take this on record? In producing a copy of producing copies of communications made between active communications. Introducing a copy of communication made by the executive engineer, PW Department, South 24 Parganas, to the executive engineer, Alipur Division, PWD, on 6th March 2024, Learned Counsel for the applicant petitioner submits that the executive engineer, South 24 PWD South 24 Parganas, has requested for land details of the work in question. Work in question, which are required in connection with the present application. Stop. A copy of the writ petition along with annexure thereto containing the land details has been forwarded by Learned Counsel for the applicant petitioner to the executive engineer, South 24 Parganas Division, PWD, by a letter issued on 9th March 2024. Paragraph. Learned Counsel for the alleged contender seeks accommodation to comply with the order under contempt. 1 month. Paragraph. Let the matter appear under the same heading on 6th May.
But sir, may I submit it through an affidavit?
Not necessary. I have just recorded, let it be on record. Next. Who is appearing for the Yes, Ms. Banerjee is appearing. You are not audible. Please unmute yourself. Please unmute.
Unmute yourself. Unmute. Unmute for an unmute.
Are you in this matter?
But the order has been complied with, right?
Order complied with,
Yes.
so let me pass. Order complied?
But I have taken instruction, the order has been complied.
Affidavit of compliance submitted on behalf of the alleged contemptor is taken on record. Paragraph, it appears that the order under contempt has been complied with. Paragraph, in view of the above, the contempt application being CPA and such is disposed of. Paragraph, there shall however be no arrears to costs as in certified receipt. Next. Item 5.
Today, fourth division.
Four.
Four matter, yesterday the matter was called, they didn't appear. Appeal and application dismissed, then subsequently they mentioned, today the matter is likely to be taken up today.
So I'll give you a month's time.
Manoj?
Let it appear. Fine. No order. Fine. No order can be passed.
That is the whole.
Item 5.
Item 5, my lord, I am for the applicant, my lord.
They have complied the order by passing the order of K1 and
Affidavit of compliance submitted on behalf of the alleged contemptor is taken on record. It appears that the order under contempt has been complied with. Paragraph, in view of the above, the contempt application
compliance, affidavit of compliance.
yes, you've taken. Being CPA and such is disposed of. Paragraph, there shall however be no order as to costs as is certified website.
Great.
Item 6.
Now, item number 6, I am for the petitioner.
Is it appearing for the first time?
Today was supposed to be for the final hearing.
Have you served? There was a direction
Madam.
for service.
তো ডিসপোজ 3 নম্বরটা অ্যাপ্লিকেশন
Where is the service? You have served the department. It has to be served on the person.
Well, the order was given towards the
Yes,
Principal Secretary, Indian Waterways.
it has to be received by the alleged contemner himself. You cannot just serve on the department. He may not be aware at all, isn't it?
So not aware of that.
Where is the service on the alleged contemner on Prabhat Kumar Mishra?
Just a second, Madam. I should. Alleged contempt service.
No service, Mr. Roy.
Yes, ma'am.
It's served on the department.
Yeah.
It's served on the department, not on the person. It's a contempt application.
My
Person-
hand they have received. That's why my
Department has received. The person has to receive. He may not be aware of this at all. Contempt application, it should be a personal service. Since service upon the alleged contemner is not complete, comma, let the matter stand over till 6th May.
একই সবই দেখি ডিসপোজ
7.
So the service is concerned, my lord, same. To the office of the contemner.
The same order. Rajiv, same order. 7. Item 8. Same order. 8. Same order. 9 also. Item 9. Same. order. 10.
But I am for the respondent. After the petitioner concludes his argument, I shall.
The last occasion, my lord, this was adjourned at the instance of the petitioner.
Yes.
But we are grateful that Lordship has been pleased to direct the matter high up in the list.
Yes. Because it has been substantially heard.
Yes.
Yes. Mr. Chatterjee is for 3 and 4. Respondent numbers 3 and 4.
Respondent number 3 rather. Metro Railway.
What
Three
about
and
the added respondent?
Lord, I am for
City
the added
properties.
respondent. I am for the added.
You are for the added
My
respondent.
learned friend was the landlord. Your Lordship order was to pay the compensation. It has been paid.
Does that matter? Occupants and
Yes.
landlord. Yes.
It has been paid. Lord. Unless he is paid, he doesn't come to court.
What does
I
that
am
mean?
always.
তোমার মক্কেল তোমাকে বলেছি আমি?
Yes.
Yes, not last occasion. Lordship, the affidavit in opposition filed by the Metro Railway, where they have admitted that the property in question has not been taken for the purpose of construction of Metro Railway, but for the purpose of giving it to the Consulate General of Nepal. That is admitted. Now, Lord, it appears from the notification under section 7 that this property was not mentioned there in the notification. But section 7, Lord, mandatory provision, description of the property should be given in the notification. This property, Lord, initial notification, this property was not mentioned. Lord, subsequently, the Lord's number 1 National Avenue, premises number 1 National Library Avenue, Lord, only first notification referred to only 105 square meter. That is required for the construction of metro railway. Lord, subsequently in 22, another notification was issued. There it was mentioned more than 5,500 and odd square meter. Lord, in the when first notification was published, we are the tenants in occupation of the property. We did not take any steps. But as soon as the second notification was published, we pointed out that this is Lord mala fide and this cannot be entertained. Lord, we took the plea that it is for other purpose. It was not believed. Subsequently, Lord, on the basis of Right to Information Act information, we came to learn that it is related to External Affairs Ministry. Lord, accordingly, ultimately, Lord, we filed an application before this supplementary affidavit before this honorable court, pointing out that it should be given. They have arranged it for giving Nepal Consulate General. And Lord, filed a supplementary affidavit pointing out that before the competent authority also, we pointed out Nepal Consulate General. Now, Lord, the railway authority came forward and filed their opposition against my supplementary affidavit, and they admitted that it is for Nepal Consulate General. Lord, therefore, my response submission would be, Lord, this is not for the purpose of metro rail, and it is admitted now in their meeting. Therefore, Lord, the landlord's role, Lord, from the order passed by the competent authority also, they have annexed with their subsequent application for releasing money. Lord, it will appear that neither the owner nor the metro railway disclosed before the authority that it is tenanted. It has been held. They have suppressed the material fact. Lord, owner intention is to anyhow get the compensation money. Initially, Lord, they filed suit for eviction under West Bengal Premises Tenancy Act. They failed. Thereafter, approach Lord Consumer Forum. They failed for our eviction. Next, Lord, indirect method through corporation issued demolition notice. We challenge that notice. That was quashed. Now, Lord, they have got the opportunity. This through metro railway, if it is acquired, Lord, we would be thrown out. Lord, your Lordship has seen the section 9 of the Metro Railway Lord, Act, Construction Works Act 1978. Lord, who are interested person, Lord, it has been mentioned. Lord, any person interested in the land, building, street, road, or passage may, within 21 days from the date of publication of under subsection 3 of section 7 of the substance of the notification under subsection 1 of the section, object to the construction of the metro railway or any other work connected therewith upon or under the land, building, street, road, or passage, as the case may be. Lord, this is the order. Lord, accordingly, within 21 days, we are the tenant in occupation. We filed our objection. Objection was heard by the competent authority. Competent authority, Lord, first finding that we have no authority, we have no locus standi to challenge it because we are tenants. And second point is, Lord, in spite of pointing out that it is for other purpose, he has avoided that question. That's why we have come before your Lordship. Initially, my learned friend took a point that it is not maintainable because appeal lies. But Lord, subsection 3 of section 9 provides that the order is final. Therefore, no other alternative but that. And Lord, another question was raised that under section 10, possession has been taken. As soon as declaration has been made, the possession. Lord, I have referred to a judgment before your Lordship of the single bench of this honorable court that it is not correct proposition of law. Now, your Lordship kindly see section 7. For subsection 2, every notification under subsection 1 shall give a brief description of the land, building, street, road, or passage. Lord, neither in the first notification nor in the second notification, nothing has been given. So far, Nepal Consulate General's property is concerned. Lord, now, Lord, they have set up, all on a sudden, they have woke up and said that my land is going to be taken up by the metro railway, and metro railway also, Lord, they have in the same tune are saying that we are acquiring Nepal Consulate General land, therefore we have to compensate them. By providing land, by dispossessing us. Though the land of National Library Avenue, number 1 National Library Avenue, except 105 square meter, nothing is required for the purpose of metro railway. It is admitted position. Now, my lord, whether it is permissible or not. That is the only question. In the meantime, Lord, your lordship kindly see, they have filed an application recently. That is, can number. That is can number 2. Lord, your lordship kindly take their can. How, my lord, this has been done? It has been found. It has been found by the competent authority. By
Can 2.
Can 2, my lord. It has been filed by the respondent number 2 and 4. 2 and 4.
Give me a minute, please.
Rail Vikas Nigam Limited and General Manager Metro Railway.
Can 2. That's it.
কেন আনছিল সেটা তো পুরো পাঠিয়ে দিছে
Yes, can 2.
Lord, your lordship kindly see, this is an application by respondent number 2 and 4, that is Railway Vikas Nigam Limited and General Manager Metro Railway. Your lordship kindly see their prayer here for releasing the for early disposal of the matter.
This is made by 2 and 4.
2 and 4, Lord. Rail Vikas Nigam Limited and General Manager Metro Rail. Lord, your lordship kindly state a come. The false statements. Lord, paragraph 2. In the writ petition has inter alia sought for quashing the notification number such and such at 12 January 2022 published by the Government of India in the Official Gazette, which was subsequently published in the Times of India on 6th March 2022 by the competent authority, Metro Railway, competent authority, Metro Railway. The notification relates to acquiring, Lord, kindly note, this is second notification, 532.634 square meter of the land of premises number 1, National Library Avenue, Kolkata, 7,27,000 for public purpose. But here also they are still, earlier occasion in their opposition they have admitted this is for the purpose of Nepal Consulate. Now here for public purpose, for construction of underground metro railway located. But kindly note it. On oath, within the span of metro corridors from Mominpur to Esplanade section of Joka Bibidibang metro corridor. The impugned notification was issued in exercise of power under section 10(1) of the Metro Railway Construction Works Act 1970. Lord, next paragraph is much more important. The writ petitioners are occupier of 1 National Library Avenue, Kolkata, 7,27,000 and claim to carry business there.
No, can 2 I am not placing. I tell your lordship why. If you lordship can 2. Kindly see the prayers in my application.
No, I am placing the document, materials.
He is not withdrawing this application, Dada. Then
No,
how
well,
will he write?
One, it is filed. When it goes against him, he is withdrawing it.
He
He
can.
can't. No. Lord, your lordship, no.
My language would be.
Lord, the admission in the pleading, that cannot be
No, there are admission in
federal law.
different
Lord,
law.
Justice Vijay Mukherjee's judgment, your lordship, no 63 CWN.
Kindly
Man
see,
can come and go, but the admission in the
admission remains.
pleading,
Admission is the best evidence, we all know. Kindly see my prayer in page 7.
that I have stated for early disposal.
Early disposal, and then your lordship was pleased to pass an order on 9th of February 2024 that operation of the order be stayed. Why? That the until I get the vacant position, Lord, the 37 crore that was paid to the landlord could not be handed over. But which I have stated here. But then, Lord, it has transpired that the competent authority has already paid to the landlord. And my application now being heard. So, my lord, I don't press this application.
But for my purpose, Lord, I will press. Lord, your lordship kindly see paragraph 3. The requisitioner occupier of 1 National Library Avenue, Calcutta, Kolkata, 7,27,000 and claim to carry on business therein. The city properties private limited is the owner of the said property and had terminated the purported tenancies. Wherefrom we get it? We are still in occupation. We have placed before your lordship all documents in support of our case, and they have also admitted, Lord, in the first line, the petitioners are occupier as tenants, and he said that he is terminated. Now your lordship will find
As tenant কোথায় বলেছি দাদা? Here, বলুন। I'm sorry. আপনাকে বিরক্ত বলুন।
Lord, your lordship kindly see, my learned friend has pointed out that occupiers of National Library Avenue and claim to carry on business therein. The city properties private limited is the owner of the said property and terminated the purported tenancies. This is tenancies. Now, Lord, kindly see. And Lord, paragraph 7. In the supplementary affidavit to the writ petition, affirmed 21st March 23, it has been alleged that the second notification for acquisition of 532.634 square meter of land has no concern with the proposed project, and the same is proposed to be acquired only to provide accommodation to Nepal Consulate General at the cost of the land user's valuable right. The writ petitioners contend that if, Lord, this is, I am pointing out because, Lord, in the opposition to our supplementary affidavit, they have admitted that it has been taken.
They have only repeated your contention here.
Yes.
So it's already there on record.
Yes, Lord, but they have stated that it is not for the purpose, for the purpose of
No,
Metro.
they have stated it is your allegation. It is not their statement.
Yes.
The writ petitioners have alleged.
Yes, yes.
So that is already on record.
On record.
So
I'm
nothing
pretty-
new in
And
the
Lord,
supplementary.
Lord, and they have
I am
admitted.
not pressing this application, Lord, my landman to hold me to the application that I made.
First, it is not being pressed.
Yes.
Second, whatever is there is nothing new. It is already in the writ petition
And
and
Lord,
supplementary.
Lord, kindly see, Lord, the order passed by the competent authority, they have annexed with this. Lord, some portion I am pressing, Lord.
That is not part of the other applications.
No. For the first time, Lord, it has been annexed. In terms of your lordship's direction, the competent authority, Lord, by this order, ultimately directed the Metro Rail to pay the awarded.
It is over.
That part is over. Lord, kindly see here, page 2.
Page 11, Lord, is the order passed.
Yes. Lord, your lordship kindly come to the second page, page 12.
Yes.
The learned advocate of the opposite party, on the other hand, submitted that the acquisition of the case land is for public purpose and taking symbolic possession of an encumbered land would not serve any purpose, and the claimant being responsible for handing over vacant possession of this case land cannot get the compensation amount without fulfilling his obligation to hand over possession of the case land beforehand. I am unable to concur with the view of the learned advocate for the claimant that the claimant did not have any responsibility to disclose during adjudication process that the case land was tenanted. The compensation amount in respect of acquired land is determined in the manner prescribed by section 26 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. And as per provision of value, the acquired land may be determined by taking into note of the market value of land specified in the Indian Stamp Act in respect of the land in the area and or the average sale price in similar type of land in the vicinity. The price of land definitely fluctuates based on the nature of possession of the landowner. If the landowner immediate possession of the case land, he is likely to get higher price for the same compared to land which is tenanted, as the purchaser in such case would not be able to get physical possession without vacating the tenants. Therefore, the fact that the portion of the case land was occupied by the tenant's third party would obviously be a factor while adjudicating the compensation amount to which the claimant was entitled. However, the opposite party, Metro Railway, is equally guilty of suppressing during the adjudication process that some portion of the case land was occupied by the third party. The opposite party also have disclosed such fact during the adjudication process, but it chose not to disclose such fact for reason best known to it. Once the adjudication process is over, thereafter, in terms of your lordship here. But therefore, from the order, it's also transferred. But they have not disclosed that we are in occupation. Both the parties, they knew. But that is, it is a collusive one. And everything was done behind the back of the general public as also the tenants for acquisition of the land. Notification is therefore, Lord, should be quashed as prayed for. Now, Lord, your lordship can you see? Now, they have pointed out that they will provide and though it is not on record, we have learned that Metro Rail is now going to provide that particular land, second notification land, to Nepal Consulate General, and they have agreed to construct a G+2-story building for them, though they have claimed G+7-story. And so far our land is concerned, Lord, as yet that has not been touched because of the pendency of this writ petition. Lord, therefore, my humble submission before your lordship, if it is not for the purpose of metro construction, for other purpose, then Lord, it cannot be acquired.
Where is the admission?
Lord, admission. Yes. Lord, your lordship will get it from there. A reply to this supplementary update. I'm just not first.
Yeah.
Lord, your lordship, this has been affirmed by one is Surinder Saini. No, it is our reply. Yeah.
Is it affirmed on 23rd November?
Yes, no problem. I'm just
Reply to your supplementary affirm.
Just a minute, Lord. Lord, it is yes, Lord, it has been affirmed on 23rd. Your lordship, right? Lord, your lordship, can you see this? Paragraph 4. Statement and submission or delegation made in paragraph 2 of the supplementary, I say, and submit that the Metro Railway Kolkata intended to acquire 532.634 square meter of land pertaining to Pension number 1 National Library Avenue. The piece of land as in question, as the same will be used for public utility service and not for any personal occupation gain. In conformity with the plan of the project, it is mandatory that the said plot of land is acquired for the purpose of execution of the project, as failure to do so will frustrate the entire project adjacent to premises number 1, National Library Avenue, Kolkata, on northwestern part of the premises held by Consulate General of Nepal. A sovereign land is located about 409.538 square meter of Consulate General of Nepal land lying within the acquisition alignment is fixed, chosen, and inseparable required for execution of the project. Your respondent gave leave to file the entire map showing the project land such and such Metro Rail project and invites the petitioner to inspect the said map, if so desire, upon notice to the advocate of the respondent court that the Consulate General of Nepal did not agree to depart their land. Well, kindly note it. Land, citing that due to such acquisition, it will lead to compromise with safety and security of their premises. But for the interest of the flagship project with national importance of Government of India and State of West Bengal, Consulate General of Nepal agreed to depart acquired portion of the land lying within the acquisition alignment if and only if, in exchange of the adequate quantum of land with the land from the adjacent premises, to restore safety and security of the premises in order, unless Consulate General Nepal land is compensated with the adequate quantum of land from the adjacent premises, the project work will frustrate to its entirety. So it was obligated for the purpose of the implementation of the project to acquire added land from the adjacent premises number 1, National Library Avenue, Kolkata, 7,27,000 for necessary swapping of land with Consulate General of Nepal land. The land being held by the Consulate General of Nepal is governed under the Ministry of External Affairs and involve international relations with the bordering foreign country. The issue being sensitive and delicate was taken into consideration with due earnest. So, exchange of land from the adjacent premises with Consulate General Nepal land is an integral part of acquisition of land for the purpose of execution of the project. Moreover, it is most relevant that the owner of the premises number 1, National Library Avenue, that is city properties, has already given their consent for proposal of the acquisition and filed application claiming compensation in the court of learned competent authority, Metro Railway, Kolkata. The owner also agreed that status of the instant writ petition are occupier of the subject land. That the instant writ petition being the occupier of the land, the claim of the objector being occupier against the notification cannot sustain.
Yes, it is admitted.
Yes. Lord, therefore, your Lordship kindly note, and it reveals from the order passed by the competent authorities, they both the landlord and the owner and the Metro Rail, they suppress the fact that we are in occupation. We are tenants. For the purpose of giving it to the owner, for the purpose of benefit of the owner. And they colluded with each other. And Lord, that's why, if it is fair and it is so Lord, necessary, that what prevented them to notify? Lord, kindly see the notification, first notification at page when writ petition 54.
Is the first notification.
Yes. Lord, page 59. Your Lordship will see page 59. Lord, serial number 1.
This is the second notification.
This is Lord. Why? This is first. And Lord, I am taking.
Page 53 is the first notification.
Page 53 it starts.
That is
Yes.
the first notification.
Yes. Page 53 starts, not same thing. I have, that is page 50, it starts. That is the Lord Gazette of India. Lord, your Lordship kindly come to page 54. Really, Lord, from Lord 50, page 53, your Lordship kindly see the description of land has been given. Lord, word number such and such, name of the premises, St. Thomas Boys School, Diamond Harbour Road, 160 square meter. Then, Lord, next, the Lordship will get the Calcutta Diocesan Association, that is Diamond Harbour Road, 2054.771. Lord, third is 42 by 4 by 2 Diamond Harbour Road, measuring 209 points such and such. Next, Lord, 4 National Library Avenue, 105.32 square meter, 326 square meter. Next, Lord, Calcutta Medical Research Institute. Lord, here your Lordship kindly, there is no Nepal Consulate, no premises number, no area, nothing else. And next, Lord, Garden Guest House, that is 70 by 2 Diamond Harbour Road. Lord, next, that is 7 St. Teresa Secondary School, 72 Diamond Harbour Road, 492 square meter. Lord, here, I do not know why they are shy to publish that the Nepal Consulate's land is required for the purpose of metro construction. Lord, in the second notification, your Lordship will find It is at page. Yes, your lordship can straightway come to page 86. Yes, it starts at page 85.
Yes.
Page 85, Lord. This is second notification dated 12th January 2022. This is under challenge before your lordship. Lord, kindly see here also. Next page 86. 4 Diamond Harbour Road, item number 1. Next, Lord, 5 Diamond Harbour Road, item number 2. Third, 4/2 Diamond Harbour Road.
No, it's not there.
Lord,
It's
Nepal
not there.
Consulate is not there. Lord, they know that the land of Nepal Consulate is required for the purpose of metro construction. For the first time, Lord, when we approached this honorable court, they have disclosed that this land is for the acquired for the purpose of compensating Nepal Consulate General. And Lord, in the map, they have shown that some portion of Nepal Consulate General has been sought to be acquired. But therefore, Lord, this is totally mala-fide process. Law doesn't permit to give land to some other person in the plea that it is required for public purpose. Therefore, Lord, the entire second notification is liable to be quashed. Lord, I do not know what is the stand of the Metro Railway in these circumstances, when they have admitted that this is not for the metro purpose. And Lord, I am not in possession of those documents. Subsequent meetings, it has been specifically held that they will hand over the possession of this portion to Nepal Consulate General, and they will also construct boundary wall and a G+2-storied building for the purpose. I am trying to get Lord, the copies of the said resolution, but it is not yet. But they must admit it. It is there.
That's all you're submitting.
Yes, Lord.
That's all.
Lord, yes, Lord, this is for the purpose of this portion, Lord. And Lord, they have said that I have no right. Your lordship can see the impugned order first. Impugned order, Lord, last annexure of the writ petition. Lord, your lordship will get it at page
105.
105A. That is not typed copy, 105A. Lord, first page, paragraph 2. The case of the objector in short is that he is the occupier tenant of the property situated at premises number 1, National Library Avenue, Kolkata, 707. And he runs his business from the same. From the newspaper, he has come to learn that the property is going to be acquired by the opposite party Metro Railway, and it is his contention that the opposite party Metro Railway has not clarified the reason for such acquisition. It is his further contention that the OP Metro Railway is allowed to acquire the said property, then his livelihood along with the livelihood of his entire family would be jeopardized, and therefore he has paid from the said premises, so that he and some other objectors who are also tenants in the said premises can make some amicable arrangement among themselves and can run their respective businesses therefrom. On the other hand, the opposite party Metro Railway, by filing counter objection, has submitted that they intend to acquire the piece of land and the same will be used for public utility service. Now, kindly note it is thereof, and not for any personal or professional gain. They have further submitted that considering the plan of the project, it is mandatory that the said plot of land is acquired, as failure to do so would frustrate the entire project. They have denied and disputed the contention of the objector content in the objection petition. However, they have stated that they are ready and willing to pay compensation as per existing laws to the landlord in the event of acquisition. I have given regard to the submission of both parties and have also gone through all the documents in the record meticulously. From the record as well as the Gazette notification, it is found that the acquisition of the proposed for the utility and interest of the common people at large. Lord, you will also notice it. Kindly note it. And the project will cause development and scope of further employment and development of the nation. I am of the opinion that the objection of the objector is incapable of holding any water, and moreover, since the objector will be at liberty to file claim case in due course for obtaining award for compensation in the event the land is acquired by the opposite party metropolitan. I am inclined to disallow the objection petition. Moreover, the owner of the said premises has given consent to the proposed acquisition, and the status of the present claimant is that of possessor occupier. I do not find any provision, nor can note it, provision in the act whereby it can be said that the claim of the objector can be sustained. Lord, section 9, it is totally contrary to section 9. And Lord, if the claim of the objector is to be allowed, then in that case, no authority can ever acquire any land in any area. As in every case, occupiers would come and ask for release of the land they are occupying from the scheme of acquisition and find no justification in the prayer of the present objector, and accordingly, it is dismissed. And Lord, that part totally regarding the Consulate General, it is for other purpose. Objection, that part of the objection has not been taken into consideration. Lord, these are two for objection with regard to the my grievance, with regard to the order passed by the competent authority. And Lord, now, your Lordship, in view of the subsequent disclosure, it is clear that the acquisition is not for the purpose of metro, but they have admitted that it is for exchange of Nepal Consulate's land. Though, by section 7 notification, Nepal Consulate's land has not been published. Lord, it is totally malified. This land is his, the Nepal Consulate's land is not required. It is not published. And Lord, mandatory provision, your Lordship, I have read that section 7, subsection 2, every notification under the subsection 1 shall give a brief description of the land, building, street, road, or passage. That has not been given. I have pointed out from this. Lord, therefore, Lord, this should be quashed. And Lord, it is a constitution also, Lord, discrimination. I am occupying there, I am running business for last few years. Lord, according to the process of law, they failed to evict me. Now, taking advantage of the in collusion with the material which appears from the competent authorities order I placed, they have annexed the collusive acquisition.
Not my humble submission would be that my land friend tried hard to see the reason why the notification should be set aside, but in my humble submission, it failed. But he said the collusion and conspiracy between me and the landlord. But we are aware of the position of law that if the collusion and conspiracy or misrepresentation are pleaded, it must be pleaded with particulars. He failed to do so, number one. And then and then he said about the admission. Kindly take my admission in my affidavit. Kindly see whether there is an at all affidavit. In the affidavit, there is any admission by the metro railway. এটা তো নাকি? হ্যাঁ? আমাদের affidavit? Blood, may I be permitted to place blood paragraphs 3, 4, and 5? আমাদের তো আইনি হিন্দু কর্পোরেশন বিজনেস কি পেটিশন নাম্বার 2 কি বলছো? জাস্ট এগুলো দাওয়া লেখা ভাই। This is our paragraph 3, Lord, if your Lordship is pleased to come. Paragraph 4. But before that, may I make this general submission that and government authority will collude with a private authority, private party, for the purpose of acquisition of a property, ignoring thereby the presence of the occupier. It is unheard of. The submissions admitted advance is devoid of any merit. Secondly, before I place it, may I tell you, Lordship, the property is number 1 National Library Avenue. Within that property, Nepal Consulate is there, and the petitioners are carrying on business there. In the case of acquisition of a private property, the notifications are issued. In the case of Nepal Consulate, a foreign state, bordering state, they enjoy certain privileges under the Geneva Convention Act, which has been adopted by the Parliament in 1962. I shall place that.
So you say that no notification is
Not
required?
necessary.
Please show me the relevant.
Not necessary, because that property is inviolable. I will place that.
So if it is inviolable, how can you take the property
No,
for the?
that is why the exchange comes. That is why the exchange comes.
You have not annexed any document to your, I
Be-
believe you need to produce these documents.
What document, my lord, would indicate?
What you've submitted just now, that in order to take Nepal Consulate's property, you don't need to include their property in your acquisition scheme. You can take the property on a mutual understanding of giving them another piece of.
In exchange.
Where is that rule?
Not, I will satisfy your lordship. Now, my lord, I have given may I place paragraph 4?
Taking away a private property to give it to compensate the Nepal Consulate. Where is again that rule?
My lord, the private property acquired included the Nepal's position, Nepal Consulate's position. But the notification number 2, which is under challenge, not relates to the occupier and the landlord. Occupier and not the Nepal Consulate. Because in case of Nepal Consulate, they enjoy certain privileges under the Act, which is enjoyed by all foreign embassies.
Please show me that.
I will definitely.
Otherwise, I do not find that this is for a public purpose at all.
Not that is. But kindly see, where is the separation I have done? Kindly see my application, paragraph 4. We do not miss the fact that the property is one national avenue, lively avenue, and we do not miss the fact that within that property, Nepal Consulate is situated. We do not also miss the fact that the plan has been issued. And in my affidavit, Lord, how the Nepal Consulate the position and how it is necessary for the project. Lord, it is no denial of the fact that this is a national project of public purpose of national interest. 3-4% occupier would render the whole project nugatory. It's never heard of money. And not the.
For the purpose of metro railway construction.
Yes.
Not if it is for the purpose of Nepal Consulate.
No. I follow. But
pointing out to some rules, some acts, some laws.
I
would like to see them.
I will definitely. I have come prepared. But the lordship would kindly consider. I will find submit the case laws also. The principles of eminent domain. When the authority or the government acquires a land for the public purpose, only remedy is available to the persons in occupation is the compensation and nothing more. That the Supreme Court has said it.
No.
There's a law.
Is this for a public purpose?
Lord,
You are giving it to the Nepal Consulate.
Lord, for the purpose of ensuring the public purpose is completed.
Well, please place your case. Let me see.
Sorry.
Prima facie, it's not very convincing.
Lord, I will submit that your lordship, I will be able to satisfy your lordship.
Please continue.
Naturally, court's conscience. Planta. I have disclosed the plan. How?
There is no document annexed to your affidavit.
Affidavit, yes, Lord. I have disclosed the plan. No. Kindly give a moment. Yes, I crave leave to the plan. And in my application at page 3.
Yes, where is the plan? Which you say you have disclosed. Where is it?
I have kindly see, Lord, the last part of paragraph 4.
Yes.
your land lying in the acquisition, may I place paragraph 4 first? With reference to the statements and submissions and allegations made in paragraph 2 of the supplementary affidavit, I say and submit that the Metro Railway Kolkata intended to acquire 532.634 square meter of land pertaining to premises number 1 National Library Avenue, 7 lakh Kolkata, 7,27,000. The piece of land as in question, as the same will be required, same will be used for the public utility service and not for any personal occupational gain. In conformity of the plan of the project, it is mandatory that the said plot of land is required for the purpose of execution of the property. As failure to do so will frustrate the entire project adjacent to premises number 1, National Library Avenue on the northwestern part of the premises held by the Consulate of Nepal, Consulate General of Nepal. A sovereign land is located about 409.538 square meter of CGN land lying with the acquisition alignment is fixed, frozen, and inseparable required for the execution of the project. Then your petitioner craves leave to file the entire map showing the project of the land, said metro project, and invites the writ petitioners to inspect the said map if so desires upon notice. This is a plan.
Needs to be submitted.
Beg your pardon?
Needs to be submitted by way of an affidavit.
I can follow.
The plan needs to be brought before the court by way of an affidavit.
No.
It's an integral part of your case.
I
Needs to come on record.
I have craved leave of that. Now this is a document of the government authorities. Lord, if your lordship wants, and I will file it with the affidavit, no problem. I have no problem. But from the plan, it will appear how the Consulate General Office, Embassy, Lord, comes into the project line. That is why the exchange takes place. And kindly see one more thing. What is their prayer before the kindly take the order, order dated not private land acquired notification issued. যেখানে বললো যে তোমরা ওই তুমি একটা দেখালে, kindly give me a moment, my lord. ওই in exchange করে দেবে. Yes, kindly see the supplementary affidavit of the writ petitioner. Petition number 2. Now, this is affirmed on 21st March. Not I draw my lord's attention to the annexure there too. Page 16. This is the annexure 4. Annexure 4. Page 4. Page 4, sorry. Written note for submission by the objector against the objection filed by the opposite party. Lord, that has been disposed of. Lord, kindly come to internal running page 6. Internal page 3 of the order.
Internal page 3?
Of the annexure. Running page 6.
Yes.
This is their submission before the authorities. When they are Lord, the objections were Lord, dismissed, and then Lord, they were and they have been offered to compensation. They came to court. There's an appeal provisions also. They didn't do that. Paragraph 14. Also, in the end, we would like to state, Your Honor, that we are not at all against the development project by the Metro Railway Authority. We would like to state that we should be treated at par. At par, Consulate General of Nepal. Hence, if Metro Railway Authority is contemplating to rehabilitate them, then they should include us also in the in their planning and development with at least 10% to 15% of the city properties private limited. Our common landlord, land being allotted for the tenant rehabilitation, that should suffice for rehabilitation of all tenants if planned properly. Lord, there is no no provision for granting land, giving the land to the to the occupiers. No provision. Only provision is not under the act is for compensation, which I am prepared to do.
That is applicable to the Nepal Consulate General
Well,
also.
that stands on a different footing, Lord. I shall show to your lordship that stands on a different footing, Lord. And then, Lord, I will also show that the principles of eminent domain comes not when the there is no denial of the fact. Kindly allow me. There is no denial of the fact this is a public project, public purpose of national importance. If such is the case, which is admitted in all hands, Lord, the question of Lord the application of principles of eminent domain comes in. Eminent domain provides that court when the government authority acquires a land, they must ensure it cannot be questioned in court. They must ensure. I am fortified by judgment. It cannot be questioned in court, but acquiring authority must ensure that the compensation shall be paid, which I have never denied. I have never denied. Because the exchange of a portion of the acquired property with the Nepal consulate is my learned friend's pain in the neck. This is what he says. I shall satisfy your lordship that they enjoy different they are of different categories of occupiers, and they enjoy different privileges, which is internationally accepted by all countries, including India. And now that your lordship wants the plan should be filed with an affidavit, I shall file it tomorrow.
Even the relevant documents showing that the Nepal Consulate General enjoys a special privilege of grant of land.
No.
Of his acquired.
Yes. I'm not. There is a Diplomatic Privileges Act 1964. We shall hand up to your lordship at the next time.
Yes,
No,
but
these are adopted. These have adopted the Vienna Convention or the arrangement.
that's a blanket decision. But I would like to see specifically that when the land is acquired, the Nepal Consulate General is entitled to an alternative land, which you are allowed to take from a private party.
It is other way around. I will say it is the other way around. When I acquire a property of private parties in which a portion, a very important portion is occupied by a consulate, foreign consulate, and then foreign that part becomes their own property. That's the law. I shall show to lordship that in their property, they may say no, we will not vacate. You carry on with your project. But here they agreed to be agreed to vacate provided they are rehabilitated. That is why the factum of exchange of the land comes into.
There is the provision.
May I file that affidavit? Then I shall show your lordship the court.
Along with all other documents also showing that there is a provision. You cannot take away a private individual's land to please the Nepal Consulate General. There is no law.
I have an international obligation under the International Act.
There is no dispute with regard to eminent domain, because public purpose you have to pay compensation.
And cannot be questioned. At
all. The petitioner is not questioning that at all.
No.
The issue is you're taking away the petitioner's land for a private purpose.
Is the petitioner entitled to get the benefit which I am providing to the Nepal consulate under the law to be provided to them? That is the question. I shall answer. Not affidavit. I don't.
If at all the consulate is entitled to the benefit.
I'm sorry.
If at all the consulate is entitled to the benefit in terms of the convention.
Yes. Yes, that's my duty to satisfy.
Please provide the documents. I would like to go through.
Most certainly, my lord. Most certainly, Lord. And now that it has hearing has started, kindly give me, Lord, 2 days to file the affidavit.
You'll come back with a supplementary affidavit.
Yes.
Should I
Let Mr. Chatterjee complete.
But may
kindly keep in your lordship mind
There's a two distinction.
Speak the microphone.
Two distinction. One is for the purpose of construction and in connection with. And my
Yes.
lord, also thing is this, my lord, that public purpose has not been defined in this act of 1978. Public purpose has been defined, so my understanding goes, my lord, under the Land Requisition Act. And I understand, my lord, there is a provision for the public purpose has been defined, which comes in the ambit of the public office. If it is a public office, then for the land can be acquired for that also. And moreover, my lord, nowhere, no allegation that I have colluded with the authority. There is nowhere the no statement. It's a statement from the bar. Tried to develop subsequently.
It has been.
Because I don't have
recorded in
any
the order.
Madam?
It has been recorded in the order annexed to the CAN application.
My lord,
which is
because I
not
tell you,
pressed,
because I tell you, lordship, my lord,
that both have.
from the petition, I can show to your lordship, there is a word collusiveness, but that is not meant for me. There is no allegation against me as well.
It's not collusion, it is suppression by both the parties.
Because I tell you, lordship, Act does not say that I have to disclose the nature and character of the premises. Only as an interested person, I have to disclose my status, my right to the property. I need not to say whether, because property is free, vested free from all encumbrances the moment Section 10 is declared.
For a public purpose.
But that's why I said, man, a public
It is
purpose,
not a public purpose.
or a public purpose has not been defined in this Metro Railway Act. That's why I'm telling lordship. Public purpose has not been dealt with. My lord, scheme was placed before the central government under Section 6. Now scheme approved, there is no challenge to the scheme. Now Section 7 published. Section 7 says that in connection with, or first notification was for the purpose of construction of Metro Railway. Second notification is in connection with. I have not disturbed my learned friend while he was arguing.
My lord, I would,
So, my lord, I will come with the thing, my lord.
my lord, I would, in my affidavit, with your lordship leave, I shall, the better plan I shall annex, including, lord, from the date of notification till what steps the authorities have taken. It are done in a chronological order, chronological.
Just a minute. My learned friend said, no. Kindly turn to my lord section, page 85.
I've seen that.
It is in connection with, not for the purpose of Metro Rail, construction of Metro Railway. First notification is for the purpose of construction of Metro Railway.
The in connection with cannot be such a wide
So, my
connotation.
lord, kindly see, my lord, that public purpose. My lord, that's why I am telling to you,
Lord,
my lord, I come with the judgment. Public purpose has not been defined in the Metro Railway Act. Has not been defined.
Not only that, in the notification, there is, it is not stated that the land of the Nepal Consulate General is
My
being taken
understanding
away.
of the argument or whatever was advancing, my lord, I like to
So
say.
that land should be included in the notification.
But I tell you, lordship,
The premise of
all along, my lord, this has been submitted for the purpose of shifting Metro, for the purpose that land of the Nepal Consulate has been acquired. So that is required to be mentioned. My lord, I'm sorry to say, my lord, that is not the possibility, that is not the intention of either of the parties. Because property has been acquired for the purpose of and in connection with the construction of Metro Railway. In the process, if a building is required to be shifted from there to there, it doesn't mean, my lord, subject to your lordship correction, that particular property is required to be acquired.
The case of the Metro Railway is that it is
Now,
acquired.
my lord, Metro Railway cannot develop their case on their own without the document. I will restrict myself to the notification itself.
Yes, absolutely.
But no one can develop their case by way of filing documents or something like that.
I have
Even
not-
Metro Railway cannot say so.
Notification does not include the consulate's.
my lord, the-
Because that has not been acquired. That might be proposed to be acquired. But for the purpose of shifting the, kindly mark the language. For the purpose of shifting the Nepal Consulate,
If it is
they
not,
require this.
if it is not within the acquired property, there is no question of shifting.
So, my lord, that might have been the scheme of the metro railway. That might have been the scheme of the metro
Not
railway.
in the four corners of the record.
My lord, the,
That is the thing, my lord, that they have to produce.
my lord,
That's why I say
uh,
prima facie not very convinced.
I shall, in my affidavit, I shall include the steps taken from the day one till date.
Will that be very relevant for this matter?
That would be why. And number one. So far,
It's for a
so far,
private purpose or a public purpose.
yes.
What
my
is
lord,
the law with this?
not
I understand that Nepal Consulate does not come under the purview of the corporate company or for the corporation, does not come under the purview. I will show to you my lord, a provision of the Land Acquisition Act to hear from your lordship whether it come under the zone of the public office or not. If it is come under the zone of the public office, possibly public purpose will be served. But I will try to satisfy on the your lordship on the next topic.
Lord, the expression in connection with Lord must have the benefit of usdem generis. It connected with the first one. Usdem generis, Lord. The Lordship will bear it in mind.
Come back with your relevant documents. Let us see.
Lord, kindly give me 2-3 days time to file it.
Counsels for the parties. Paragraph on prayer of respondent numbers 3 and 4, liberty is granted to submit a supplementary report in the form of affidavit,
Yes, yes.
annexing relevant documents. Paragraph.
To annex the relevant records, Lord. Lordship would kindly say that.
Relevant documents.
Relevant documents all. Yeah. Relevant documents.
That is why.
No, it's perfectly all right.
Advance copy may be served upon ourselves.
Please do that.
Advance copy গুলো দেবেন তো পুরো থাকতে হবে তো একটু।
Especially to the petitioners.
No. I will never
Council has to.
ignore Mr. Ghosh. He's a tough.
Recorded that the application number.
Yes.
And
Application being CAN 2 of 2024 is not pressed by learned counsel for.
3 and 4.
No, CAN is not 3 and 4. CAN is 2 and 4.
2 and 4.
2 and 4.
Yes.
Learned counsel for respondent numbers 2 and 4. Still, let the matter appear under the same heading for further consideration. On 8th April, next Monday.
Could it be on next Tuesday, Lord? Huh? Could it be on next Tuesday? Because I tell you, Lordship,
9th April.
no.
It's a Tuesday. 9th
At the top.
Yes, absolutely.
Otherwise, my lord,
9th April.
Yes. Very well.
9th April, fairly at the top.
I'm grateful.
Your lordship on the last day, though my lord, the interim order was not passed, your lordship directed them not to take any action. They are till now we have been unaffected. But kindly not note it.
There is no
They not
noting
take
to
it.
that effect.
There is no allegation from him, Lord, from the.
Noting to that effect.
Yeah.
And I'm sure when Mr. Chatterjee is leading, then
Yes.
nothing will happen. In the
No. I would. Matter is pending. How can I do that? No, that cannot be the advice from me, at least. Otherwise.
Item 11.
Oh, তাহলে ঠিক আছে।
Service complete.
Service complete, my lord. This is the
For the private respondent in this matter.
matter what happens, my lord.
State.
My lord, in this matter, last day, my lord, reading there after notice indicating that we are appearing for this case, but we are not in this matter. My lord.
You are not appearing.
Not in this. Last occasion, my lord, কোথায় জানবি? And we have collected the name on the office of
Where is the service on the state?
গাছ কাটার না আমার ভাই রাস্তা করতে মেটাল রাস্তা করতে কি আমার
Before my learned senior friend starts, my lord, with my lord's leave, may I only.
Service is not your appearance.
No,
It's not a very.
I'm appearing led by Mr. Mahata.
what happens, my
May I only indicate, my lord, that my lord, the allegations made, my lord, does not fall under my lord group 1, my lord.
my only case is that, my lord, there was a metal road. My land, there are 3 plots of land, my lord, one out of which one is a patta. I'm a patta in one of the land.
metal road by virtue of some scheme, my lord, it has been now non-metal road. It will be metal road, and my lord, for the purpose of my lord, metaling the road, my lord, they have carved away my property. This is my allegation, my lord. And my lord, I made representations after representations, and I also, my lord, give a notice demanding justice that has not been considered and not been disposed of even, my lord. My only prayer, my lord, can come to page 11, my lord. To stop now is a matter of 2022, my lord. Now,
Why have you implemented the private respondents?
because they are in HON'BLE with me, myself, my lord, and I have filed my lord, petition suit with them also, against them, or other.
So that's a different aspect.
That is different aspect. Only thing is, my lord, for the purpose of my lord, metaling the unmetal road, my lord, they have carved away my property.
So you say, in other words, the government has encroached upon your
My
portion of
property
your-
has not been acquired, and no acquisition, and no notice has been given for acquisition. And my lord, kindly come to my prayer, my lord. Prayer one, and now I do not know. I hope, my lord, it has already been metal. Prayer one is that just to stop and restricting the extension word. I do not know what is the situation now after 2 years, my lord. And prayer two is, my lord, to restore the plots of the petition as
Yes,
it is.
sir.
And my lord, the main thing is that my representations and my notice given is 30. Let them
29, 30, 31.
let them dispose of my representation. Is a long is given on 19th of April 2022.
Page
Yes, sir, there,
29 is the representation.
Yes, it starts from 20.
To restore the plots and my lord,
Yes,
this is my only case, my lord.
that's your case. Yes, Mr. Dhar?
But without entering into the merit, allegation is against the panchayat authority.
Yes,
A
definitely.
panchayat, that determination falls under group 5.
No.
But it cannot come under only because someone has constructed a road over his
Land.
personal area, personal land. That doesn't come under the ambit of group 1 land. But since his allegation is against the Gram Panchayat, that they have illegally constructed a road over his personal land.
If you get to my
Falls
acquisition, my
under
lord.
the determination of panchayat, that is group 5, not group 1.
Kindly see the authority, my lord. It is acquisition, my lord.
Gram Panchayat is
They have
allegation.
acquired without
acquired.
giving, without taking due
Can the
process.
Gram Panchayat acquire?
Yes.
This is this is where I am, Is it that, my learned friend is complaining about or challenging any acquisition proceeding so that it
It
will
has
fall?
been made by the panchayat, but the utilization is by the government authorities.
Please.
So there is no reason why
Look,
this
well-
court cannot entertain the writ petition. Because if the acquisition has to be done, it has to be done by the government authority,
But
not the
my-
panchayat.
May I, my learned
Yes,
My
Mr. Dhar.
learned friend is not complaining about any or not challenging any acquisition proceeding. And it is on
It's
the
just the
basis
other
of,
way around. He says
May I
that
say,
it
madam?
has been taken without acquiring.
may I say, this is not his own personal land. This is a joint land.
Maybe.
I am also an owner, my lord, and on my written request, my lord, the panchayat has made this road.
Oh, that's why you're so vocal. I understand.
No, but apart from that, my lord, because my similar matters, my lord, 4 or 5 similar matters I have done, and that is under group 5. My lord, only because of that, my lord, I was vocal that, my lord, under group 1, my lord, this matter doesn't fall.
Well, I feel it's absolutely under group
very
1
well, madam,
because
that
he's
is-
asking for acquisition of the land or
New
compensation.
facts has now come, my lord, regarding determination, my lord, I was not taking that plea. My lord, since one of the co-sharer has given a consent to the panchayat authority to
Immaterial.
construct,
Immaterial.
my lord, this fact has not been placed by the writ petitioner.
One of the co-sharers may give consent to set the house of the petitioner on fire. Immaterial.
That's true, my lord. All I am saying that this consent has not been stated in the writ petition.
He's not aware. Writ petitioner should not be aware of this. It is done surreptitiously. Since a partition suit is going, you can understand the scenario.
Partition suit
That
and another.
it should be considered.
Consider.
Dispute between the co-sharers. One co-sharer says, take away his land.
I say that construction where it has been made doesn't belong to them. They are, my lord, occupying a different portion of that land, and my lord, where it has been constructed, I am occupying that portion of the
Let
land.
the
And
representation be disposed of. You'll have your chance before the authority.
That was.
Then, kindly, direct the authority to dispose of the representation upon giving
Absolutely.
all the interested party and
Magistrate.
hearing,
Absolutely.
and also the joint demarcation. Because his allegation is he is not possessing what he should be.
If the joint demarcation, the authority finds it necessary, the authority
Yes.
will do it. The court will not
Yes.
direct. A simple case is being made complicated.
It is pending, my lord, factual.
The district magistrate will do it, Mr. Dhar. District magistrate will do it.
খুবই ভালো হবে। Yes, yes. My lord. My lord, DM is the authority, my lord. DM is.
DM.
Let the DM consider. Yes.
During election time, Mr. Dey is right, at best, my lord can send it to SDO or BDO. DM.
Matter is pending till last 2 years, my lord. Whatever it is, my lord.
SDO, BDO will have no work during election. Only
Let
the
them
DM
take-
will have work.
DM would be super busy.
Let them take
Election
time, my
officer
lord. Let them
of
take
that
time.
particular district.
3 months. কবে আসবে? June শেষে আছে।
I'll grant you 2 months' time. Election will be over by 4th.
Then kindly grant us three months time.
That very well. Affidavit of
নাহলে
service.
করে উঠতে পারবে না, ঠিকই। এপ্রিল, মে,
But then it counsels for the parties.
2 মাসের
The grievance of the petitioner is that the respondents have, the respondents are constructing it is a concrete road,
metal road, my lord.
metal
Is being done.
are constructing
Previously it was unmetal road.
by encroaching upon
Maybe
a
two
portion
বছরের
of the
মামলা বসতে সময় লেগে যায়।
land
তখন মামলা ফাইল করেছেন তখন চলছিল কাজ।
without acquiring the said portion by due process of law. So, law, comma, far less paying any compensation to the petitioner. The petitioner submitted a representation in this regard before the consult authority on 19th April 2022, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the respondents submits that the second respondent be directed to consider the representation in accordance with law. Paragraph. Learned counsel for the private respondents submits that they are co-sharers, that the private respondents are co-sharers in respect of the plot in question. And since the road is being constructed by the panchayat, the matter ought to be dealt with by the panchayat authorities and not the district magistrate. Paragraph 1. I consider you, since the petitioner alleges that a portion of his land is being utilized by the respondents without acquiring the same by due process of law, comma, the matter needs to be dealt with by the district magistrate, comma, North 24 Parganas, who may take necessary steps
কি বলছো?
in accordance with law in connection with utilization of the land as alleged. Paragraph in view of the above, comma, the petition is disposed of, directing the second respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner and the private respondents, comma, in accordance with law.
Not only one indulgence.
And, and let-
One more sentence, my lord, is maybe included, my lord. It is made clear, my lord, if authority at the, while hearing the dispute requires any joint inspection, authority is at liberty to do it.
and my lord,
Accordance with law বললাম ওখানে করুন। In course of
Second, নিচে দেখাবে।
considering the representation, comma, if the authority finds it necessary to hold a joint inspection in order to demarcate the utilized portion of the plot, comma, the authority shall be free to do so.
and my lord, one more thing, my lord, let them dispose of by passing a reason order, my lord.
Disposal is always by reason. order.
Let that or
Dispose of.
this
That doesn't mean a cryptic order.
Only one thing, my lord,
Disposal is always a
a
reason.
submission that I've made, my lord, that it doesn't fall under this, my lord, group, my lord, may kindly be, my lord, recorded. Well, since the, no, my lord, sorry to, my lord, interrupt, my lord, but since the allegations are against the Gram Panchayat, my lord, it doesn't fall under the, my lord, group 1 land, my lord, it falls within the group 5.
কোথায় গ্রাম পঞ্চায়েত বলছি? কি বলছো? ওর সাবমিশন করুক। রিজিনটা দেবে না? তাহলে দিল না তো। ডিসপোজ অফ করবো না।
Since
জমিতে তাহলে বিল্ডিং ও তৈরি হলে কর্পোরেশন এনে গিয়ে ল্যান্ডে চলে আসবে।
against the panchayat, comma, the matter falls under the fight of the
অ্যাপ্লিকেশন কিছু চ্যালেঞ্জ করছে না।
তারপরে ওটা থাকবে।
So, my lord, within 3 months, they will dispose of
3 months.
after hearing all the necessary parties.
Yes.
Get it. That would be communicated within
7 days.
fortnight,
The decision.
Fortnight.
After the order is passed.
7 days, 7 days.
ওই অর্ডারের পরে।
And pass a order.
এটা তো করে দিলাম আর কি
আবার
চাই?
কি চাই?
I am led by Mr. Mahata.
এটাও করে দিতে।
হচ্ছে তখন থেকে।
এর নাম দিয়ে দিন।
না, motion is still on. হ্যাঁ, তারপরে একটা লাইন অ্যাড করুন। It is for the subject that next. Action. Go on. এই দিদি এয়ারটা কি? This is that matter which is not maintainable. Yes.
Item 13. Item 13 will not 12.
Item 12.
13.
Let it be dismissed as not maintainable. Yes? Yes, yes, I've seen that. None appears for the petitioner, no accommodation is sought. Paragraph, the matter pertains to the West Bengal Land Reforms Act of 1955. Which is a specified act. Paragraph the options here. Tribunal Act.
Direction চাই।
Petition.
Deputation collector can hold the arbitration.
Paragraph. According, paragraph, the petition is dismissed as not maintainable. Next,
Not mentioned, huh? Not mentioned.
My lord, I appear for the petitioner. My lord.
I beg to appear on behalf of the state, my lord. This is my affidavit in opposition.
There was a direction to file a report, my lord. My lord,
report, yes.
My lord, so far as my lord, the petition, 44 katha of land, my lord, was requisitioned under the provision of West
Received a copy?
Yes, my lord, I have. Yes.
You don't want to file an
My
exception?
lord, I am relying on one of the paragraph in their report, my lord. If my lord, it's for transfer, we can, because today, my lord, what has happened, my lord, under the West Bengal Premises Requisition and my lord, Control Temporary Provision Act, a land of 44 katha was we got requisition. That was done in the year, my lord, 1973, 12 September 1973. Under the Act, my lord, Section 25B, my lord, that has to be done, released within a period of, my lord, 25 years. In the report, my lord,
It's a temporary act.
yes, in the report, my lord, they have specified that it ought to have been released on 23rd of October 1998. However, my lord, it was not released. It was actually released pursuant to this court's order, my lord, on 30th April 2021. So, my lord, I have a claim for means profit from the period of my lord, 23rd of October 1998 to my lord, 30th of April 2021. There were several letters, my lord, legal notices were given. Now, in the report, my lord, they have said, my lord, they have not considered the claim of means profit in paragraph 11 because the first land acquisition collector was under an impression that we have given a go by to, my lord, the claim. That is there in paragraph, my lord, 13 of page 17 of the report. What I am seeking today, my lord, at paragraph 23, my lord, they have said the first land acquisition collector has the authority, my lord, to adjudicate by way of an arbitration of a claim of means profit. Today, what I am seeking, my lord, I am ready to go, my lord, if you direct land acquisition collector to initiate an arbitration proceeding. I have a claim of 15 crores and let it be adjudicated before them. And whatever will be the outcome, my lord.
During pendency of the writ petition, the petitioner has already received, my lord, 12 lakhs of rupees.
Look, my claim is of 15 crores.
My lord, it has been calculated by the land acquisition officer and he has received it during the pendency of the writ.
Provision for arbitration?
My lord, there is a provision for, my lord.
There is no provision.
There is a provision.
Where is it stated that there is a provision for arbitration with regard to?
My lord, it's paragraph 23 of the report. Page 9.
This is government premises let out to private parties. This is the other way around.
This is not, my lord, applicable.
Paragraph 23 says,
yes,
this is in respect of government premises let out to private parties.
Yes.
But here it's the other way
my lord,
around.
in that
Yeah,
case, my lord, will
it's
have to, my lord,
contra.
decide because otherwise, my lord, I
It's
have to
contra.
have a remedy, my lord. If my claim is of 15 crores of rupees, my lord, the CID had its office there. My lord, they were supposed to let out, released under the act in 1998. They kept, my lord, the property in their possession till 2021, my lord.
And after the calculation, it has been 12 lakhs has been already been paid to the petitioner.
My lord, will also see, my lord, the first paragraph.
Without any
that the
protest,
first
he
land
has received the
acquisition
12 lakhs.
collector
He
has
has
got the
received the
mandate
12
from
lakhs without any protest. During the pendency
the
of the
first part of paragraph 23, my lord, to the reasonable and fair rent in respect of private premises hired by the government for public purpose. Is a public premises which has been hired by the, my lord, the government.
But where is the provision for arbitration?
My lord, under the act, my lord, there is no provision.
Then I cannot send it for arbitration.
My lord.
My lord, then, my lord, there has to be a determination, my lord.
And this determination was done by the first land acquisition collector.
My lord,
The 12 lakhs.
that is, my lord, the rent they pay. But, my lord, the mean profit is something different, which has to, we have, my lord, in the repetition, we have given, my lord, the valuation report by the empaneled valuer. What would have been the, my lord, the valuation?
There is the document showing that they have
And
the
my lord,
rents and not the occupational charges.
things is that without any protest they have received.
You are receiving the amount, where is that?
Milord, that was, Milord, which they had said, Milord, that in 2023, Milord, there was a payment made, which is, Milord, the rent.
Rent is not mean profits.
Milord, my lord, you'll see paragraph 15, which is the document they are saying in the report. They say that DIG CID was requested to deposit the outstanding rent from 1/7/28 to 29/4/2021. The said outstanding rent amount, Sadan sir, was
My lord,
received by
under the Land Acquisition Act, the provision is the rent compensation. Now the rent has already been given.
It is
That
not
is the
the
compensation.
land acquisition, my lord. Via a letter memo, they communicated to the requesting the collection of introduced rent amounting to the final rent amounting to 12 lakhs. Was
Well,
paid
it
to
is the land
petitioner,
acquisition.
deducting the my lord.
This is entire due rent.
Yes.
This is not mean profits.
My lord, rent, my lord, under the land acquisition
Milord,
proceeding, there is no question of means profit. Only the rent compensation.
Occupational charges.
Rent compensation. Rent compensation. The law provides for rent compensation that has been.
See the law, the act.
My lord, kindly fix it
And
in
my lord, will kindly see the paragraph 13 of their report. They say they were under a misconception that I have forego the claim. That is why they have not taken any action with regard to
that
payment.
is why the payment has been made. Therefore, you have forgot that 12 lakhs that has been that is why that 12 lakhs has been paid. And there is no protest. No, there is no question of my lord claiming without any protest.
Milord, that was done, Milord. They received through Milord. If my learned friend is saying Milord, then I have to file a report, Milord, exception to this report because this is the document they are showing Milord in the report.
How he will improve by filing exception?
Milord, where is the state?
Where is the provision of means profit under the acquisition proceeding?
The act only speaks of compensation.
Compensation.
Milord, they say Milord the payment of rent.
Not released.
As it is, as my lord, it is my lord the unauthorized occupation, then my lord the rent has been given, the rent compensation that he is entitled to. Use and enjoyment, my lord, the rent compensation has been given 12 lakhs. And he has received it without any protest.
Milord, my claim I have all along retained.
Claim, whatever may be claim may be,
there on the part
claim
of
may be
record,
15,000 crore, claim may be 15,000 crore.
Determination.
Under which provisions of law?
Documents,
Under which provisions of law it will be determined? Under which provisions of law? It will be determined under which provisions of law?
You have determined under which provision?
My lord, rent compensation.
Under which provision?
My lord, acquisition, land acquisition provision.
How can land acquisition provision be applicable in this case?
My lord, we shall bring all that GHOSH that the Premises Acquisition Act, and it is ultimately governed under the Land Acquisition Act.
I think it will be better if you use an exception to this.
My lord, I shall.
Annexing the documents because
I
it says you have received the amount without any demur.
Then I shall, Milord. I was, Milord, relying on their, if it is the arbitration, since they are not willing, Milord, I shall use my.
Not arbitration.
Milord,
There
I
is
shall
no,
use.
provision for arbitration. Otherwise, I could have sent it for arbitration. There's
I
no
shall.
provision.
I shall.
And please also find out if there is any provision for
My
arbitration
lord,
in this case.
that I will do.
Report in the form of affidavit
My lord, may I have kindly leave, my lord?
Respondents is taken on record. Paragraph on prayer of the petitioner liberties petitioners. Comma liberty is granted to use an exception to the report. Paragraph. There should be a solution to this. Cannot be arbitrarily done. And what provisions are being followed? That is also required.
That Milord,
There are several GOs, my lord, which deals with the rent compensation or requisition compensation, because this is under Act 4 which is a temporary act, requisition and acquisition, my lord, of control 1947 Act. My lord, there are several GOs. When property is under requisition, what would be the requisition compensation or rent compensation? For the purpose government is using that particular land for that particular period.
The issue here is the land was not vacated, not de-requisitioned after the act, after the lifetime of the act. So
I'll come back.
Period.
I'll
the
come
government
back.
has to pay compensation. That cannot be arbitrarily calculated. There should be some provision.
The matter will hear, my lord.
Yes.
Time.
Let the matter appear under the same heading. 19th April.
My lord, kindly give more some time because I have to look into this, my lord, the GOs.
9th May. Next. Okay. Yes.
But I am for the petitioner.
Service complete.
Yes.
Mr. Modul, you are appearing?
Service to the check. My lord, complete, my lord, delivered. Delivered to the private. Yes, yes, my lord, private respondents as well.
Served.
Served.
Where is the original?
So there are two affidavit of services I just handed over, my lord. One sent, my lord, initially, that was, my lord, that did not, my lord, receive. The second one, my lord, received.
Yes.
My lord, there is a road, my lord, a PWD road, my lord, in front of the petitioner's house, my lord, which is, my lord, connecting to the main road. My lord, that the private respondents are making a construction over that, my lord. My lord, I filed my representation, my lord, kindly sees, my lord. Starts at, my lord, page 23. It starts at, my lord, page 23, my lord. The respondent number 3, my lord. The assistant engineer PWD Holdia Construction Subdivision 1, my lord, he is the authority, my lord, appropriate authority, my lord. It falls under his jurisdiction, my lord. He is to consider his representation, my lord.
Yes, Mr. Modul.
Inquiry has been made that the private respondent, including the petitioner, includes the PWD. And as per the department already issued a 10-1 notice.
10-1 notice has been issued upon both of them. So remove all the encroachments.
My lord. Yes, yes, my lord. I cannot, my lord, defend that.
Instructions, affidavit of service submitted by the petitioner and instructions submitted on behalf of the state respondents are taken up. Paragraph, none appears for the private respondents despite service. Paragraph, the petitioner claims to be the recorded owner of the plot in question and submits that the private respondents have raised unauthorized construction by encroaching upon a portion of the PWD land adjoining his property, comma, thereby obstructing his egress and ingress. The petitioner submitted a representation in this regard to the concerned authority on 10th October 2022. This is yet to be considered. Stop. The petitioner prays for a direction at the earliest. Paragraph, learned counsel for the state respondents submits that upon inquiry, comma, it is found that both the petitioner and the private respondents have encroached upon PWD land. Notice under section 10(1) of the West Bengal Highways Act 1964 has been issued upon both the parties. Paragraph, in view of the above, comma, this court is inclined to hold that since the petitioner and the private respondents are found to have encroached upon PWD land and proceeding under section 10 of the Act of 1964 has been initiated, comma, the respondent number? There
Three,
are
my
two-
lord, my lord.
Three.
My
The third
instruction is
respondent be directed to take the proceeding to its logical conclusion within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, comma, in accordance with stop, the concerned authority shall be at liberty to remove all encroachments upon PWD land upon following due course of law. Disposed of, rejected.
grateful.
Next.
May it please the Lord's Lord. Lord, very short matter,
Respondents,
Lord, only state response. Sir, state, we have served on the GP and sent also by post to the other, only state.
give me a minute, please.
You also? But earlier the matter was adjourned once, I'm told, and somebody appeared for the state.
For the state,
Copy দিয়ে আসা উচিত। অর্ডারটা আছে আমাদের কাছে?
no, only the petitioners had appeared,
Very
not the state.
Lord,
May I request Mr. Day to appear in this matter? State has been served. Please serve a copy of the writ petition to Mr. Day. Yes, so that we can deal with the matter.
may I come back tomorrow, Lord, or now proceed?
Make use
Oh,
of it.
wait.
Yes.
একটা copy দিয়ে দাও। Lord, Lord, my predecessors, Lord, I just give you Lordship the facts in a nutshell. My predecessors, they owned 12 decimals of land in Lord plot number 6, LR plot number 6 within Moujam Lord, Chopradhar, Islampur. Now, on the same Dag number, there was another 10 decimals of land, which Lord, they were occupying from 1967, which belonged to the government, admittedly. In 2022, I made a mistake. My grandfather was intelligent. He grabbed the land. I applied to the state that you granted a long-term lease to me. We were in occupation for 54 years. Nobody bothered about that. When I made a representation that please issue a long-term lease on accepting money, since it is within the same boundary wall, already encroached, so that I can use it properly. Lord, the departmental secretary, he directed the ADMLR that you file a report to that effect. My lord will kindly take note, page 120, 121 of the petition. First, come to my application, my lord, is at page 119. Take 119 first, my lord. My lord, kindly got it, my lord.
Long-term lease,
Yes, I said that please find here with our earlier letter dated so addressed to so we have applied for long-term lease over the above property, which is just adjacent to our proposed possessed land and under the same boundary wall. This is very important. It is within my possession. We had possessed about 12 decimals of land. LR number so ma'am, if you get the vested portion of the land, which is currently in abundant situation on long-term lease basis, then it will be helpful for us to carry on business. But kindly turn over the page. Apropos to my application on 4th of March 2022, Additional Secretary, Lord, Department of Lord Land and Land Reforms writes to the ADMLR, Uttar Dinajpur. He, Lord, second paragraph, the undersigned is directed to forward herewith the copy of the letter to from Hansraj Dugar, that's the petitioner, which is self-explanatory, and request him to inquire into the prayer and submit a detailed proposal complete with all necessary information. Lord, kindly turn the page again. Lord, the secretary, page 120, 121. Again, further letter was issued on the same terms by the departmental secretary. Lord, suddenly the situation got changed at page 124. 124. The same secretary now, he, Lord, by two letters of March and May said that you proceed with the long-term lease, submit a report. In September, kindly see what he writes. With reference to the aforesaid memos, in connection with the aforementioned subject is proposal for long-term. 124 দাদা, 124. Proposal is long-term lease. On my proposal, he is directing, with reference to the aforesaid memo in connection with the above noted subject, the undersigned is directed to request him to take over possession of the land in question and display a board there proclaiming that the land belonged to the collector and should not be trespassed here. Lord, my application, which was taken up for consideration for grant of long-term lease, Lord, suddenly it is converted into a eviction proceeding. An eviction proceeding. Now, if I am kindly request your lordship to most kindly come back to again 121 for a second. Kindly see, Lord, he asked for a detailed proposal from the ADMLR. The secretary asked for a detailed proposal from the ADMLR at page 120 and 121. Now, page 124.
There is one word, if feasible.
Yes. So that proposal, I could have understood that proposal was placed, feasibility was judged, that was rejected. That doesn't appear from 124. But I'm grateful to your lordships. That feasibility doesn't appear from 124. That
Was invited if feasible. If it is not feasible, no proposal is necessary.
it doesn't even say that the proposal did not come. Kindly come back to 124.
What is you asking for in the report?
Lord, today I'm asking for your lordship is after this what happened. Lord, I'll just show you also 1 or 2 pages. Kindly now come take 127. 127. Now, apropos to the letter of the secretary, now the BLRO writes to me asking me to hand over possession. And the last line is very important. In accordance, you are requested to remove any valuables and structures laying there that belongs to you by 20th October. So that they admit that I am in possession. That is why they want removal. Thereafter, what they did, they went to the subdivisional magistrate and filed a 144. By the 144, the magistrate directed that I should not enter into the land that I am possessing. Now, that order has lived his life because that only for 60 days, that was passed sometimes in October 2022, page 128. Lord, I am not challenging that 144 order before your lordship. That has lived his life. But today I am before your lordship only for 2 prayers. One is that they should consider my application for long-term lease. If that is feasible, not feasible, they should come back and report to your lordships, or they should take a decision, number 1. Number 2, if they want to evict me, for that, not the West Bengal government premises eviction of unauthorized documents act will come into play. That's a so-called notice under section 3, adjudication under 4, then an order, then appeal. They cannot jump everything, and just by a stroke of pen, they cannot evict me since I'm there for a long period, and admittedly I'm there. So let them consider my proposal, because I am ready to pay the revenue to the government. And government was taking up the issue, Lord. Nobody would be benefited by this.
Yes, Mr. Dev.
That will be considered by the authority, my lord, and my lord, after passing that order, my lord,
Let them consider my prayer. If my lord sees my prayers, my lord.
And no coercive action.
Yes, but I'm so grateful to lordships. So grateful to lordships. And these.
Yes, my lord, they will pass the order in consideration of the approach. And if that is final order is passed, my lord,
He'll have an opportunity of appeal. Yes.
No, my lord. They will consider the prayer for grant of long-term lease. If they release, then they will, Lord, if they want, may initiate proceeding. So first is consideration. Second is, my lord, kindly protect my right, and not let page 127 be quashed. The order, my lord, for removal.
No question of quashing. I'll ask that no coercive action be taken.
As a lordship. And this will be kept in abeyance. Or they will not be prejudiced by this while considering my prayer for long-term.
When I say no coercive action,
Wait.
so everything automatically
My lord.
goes into abeyance.
My lord.
Gets stayed.
My lord, I'm grateful to this. Lord, may I take your lordship's leave for a minute?
Service, none appears for the respondents, despite service. But they record the please have a copy to Mr.
I have already given.
Paragraph. Heard learned counsels for the parties. Paragraph is contended on behalf of the petitioners that the petitioners are that the predecessor in interest of the petitioners was the recorded owner of more or less 12 decimals you own, isn't it?
12 decimal I own.
12 decimals of land in LR plot number 6, comma LR Khotian number 94, comma Mouja Chopra Jhar, CHOPRAJHAR, Chopra Jhar Bazar, comma jail number 60, comma police station Islampur, comma district North Dinajpur, and after his demise, comma, the petitioners, being his legal heirs, have inherited the property. The remaining is another 10 decimals.
Yes.
The said predecessor in interest, as well as the petitioners, have been occupying another 10 decimals of land in the same plot within a common boundary wall as the petitioners essay for property since long. Stop. The petitioners applied before the government for issuance of long-term lease.
Yes, madam. It's been 190.
Long-term lease. It said plot of land. It's admittedly government land. Choose. On when did you apply the date?
Madam, we have applied it on 2nd February, madam.
2nd February 2022.
Yes, madam.
On 2nd February 2022, pursuant to which the Additional Secretary to the Government of West Bengal comma, by a letter issued to the Additional District Magistrate and District Land and Land Reforms Officer, comma, Uttar Dinajpur on 4th March 2022, comma, requested the latter, LATTER, to inquire into the prayer and submit a detailed proposal complete with all necessary information and documents, comma, if feasible. Stop. A similar letter was issued by the Additional Secretary to the Government of West Bengal on 20th May 2022. Stop. The Additional Secretary, comma, by a letter issued on 22nd September 2022, comma, requested the Additional District Magistrate to take over possession of the plot in question and display a board therein proclaiming that the land belonged to the collector and no one should trespass thereon. Paragraph, Learned Counsel. No. Right. By a letter issued on 13th October 2022, comma, the Block Land and Land Reforms Officer, comma, Islampur, comma, Uttar Dinajpur, requested the petitioners to remove valuables, comma, if any, and structure lying on the plot in question for taking over possession of the plot by the government. Stop. Paragraph. Learned counsel for the petitioners submits that the application made by the petitioners for grant of long-term lease was not considered by the authority who arbitrarily decided to take over possession of the land in question without taking recourse to law.
That letter of BLRO is
13/10/2022. Nothing has been done till now. It's a continuing cause of action. So delay will not really matter.
And the matter was filed in the year 2022. This is the requisition of 2022. This is the 2022.
This is a 2022. Without taking recourse to law. According to learned counsel, even if the government wants to recover possession of the plot in question, which is admittedly occupied by the petitioners since long, the state should take recourse to the West Bengal Public Land within bracket eviction of unauthorized occupants bracket closed Act, 1962, and not proceed to evict the petitioners therefrom. Illegally and arbitrarily. Paragraph. Learned counsel for the respondents submits that the application made by the petitioners for grant of long-term lease be directed to be considered by the who should consider, Mr. De? District Magistrate.
Additional, that is the respondent number 2.
Yeah, additional
And
secretary, ma'am.
all the letters are, my lord, that point, my lord, your lordship, that my only contribution, my lord, that is the order of the BLRO was on 10, my lord. And if that is, my lord, that is the order of the BLRO, my lord, 13 October
2022.
2020. And they filed the application before High Court
On 30th December 2020.
on 30th December 2020.
Immediately
that-
thereafter.
That must be.
Immediately thereafter.
No, I am not of that point, my lord. That is whether till that is force or not. We have already taken the position or not.
This is a submission that we have till date we are in possession, madam. It is within our boundary.
That I've recorded, that they're in position.
Only for that is.
So let the application be considered.
Application will be considered, my lord, by whom? My lord, not in my name, my lord. The law is filed an application, that application will be considered by them.
By the second respondent.
Yes, ma'am.
Second
Additional-
respondent. Stop. Also,
Additional- additional-
since the the Block Land and Land Reforms Officer intended to take over possession of the plot in question in 2022, it cannot be ascertained as to whether the plot is still occupied by the petitioners. I have just recorded your submission. Paragraph in view of the above, this court is inclined to hold that since the application filed by the petitioners for grant of long-term mining lease is pending before the authority, comma, the concerned authority being the second respondent herein, be directed to consider and dispose of the application within 2 months, from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioners, comma, in accordance with law. In the event, একটা line করুন এরপরে, the decision taken by the authority shall be communicated to the petitioners within a week thereof. Paragraph, in the event the application filed by the petitioners is decided in the negative, comma, the concerned authority shall be at liberty to take necessary steps for eviction of the petitioners from the plot in question in accordance with law.
If not already done, my lord. If not already done, as because my
Kindly
lord,
record our
what is
subject,
law?
my lord, taking
That is
instruction
my lord.
till date, my lord, we are in position.
As
Kindly
because
record.
my lord, till date, that is my lord, the
Is decided in the negative, and ওখানে add করুন, and the plot is still in occupation of the petitioners. Disposed of which actually?
আমরা পয়সা নেই স্যার, শুধু ইয়ে হয়েছে।
Long term lease. Long term lease. Pension matters.
I am appearing for the petitioner in this. I am for the petition. It was heard by your lordship. On the last occasion, my lord, and one occasion, one of the past occasions, the matter could not be decided because of one paper was missing. That paper, my lord, I sought leave of your lordship to disclose it. That was the acquisition notice.
All right. Pending disposal of the application. Pending disposal of the application, no coercive action be taken by the respondents against the petitioners in respect of the plot in question.
right.
Well, there was a requisition of land
So,
for,
copy of this.
yes. Malad, kindly come to page 3 of the said supplementary first. Malad, this was the requisition notice. This was of 1966-67.
Yes.
Well, our plot number is 320 and 366. Well, 320 comes in the middle, 311 to 321. And 366 coming in the very next stanza, 341 to 371. These were the requisition for fishery. Mala, these lands were physical possession was not taken. Accordingly, and this project was not effectively implemented. Accordingly, this court was moved by some of the owners of the land. And the Honorable High Court, my lord, passed an order directing that will appear at page 77 of your lordship's petition.
Yes.
Well, may I place it for your lordship? The contention of the writ petitioner is that a fishery consisting of the several plots having an area of 46.81 acres belong to our father, late Rajendra, was requisitioned by the government of West Bengal by an order of November 10, 1966 in LA case number 42 of 66-67 under the provisions of the West Bengal Fishery Requisition Act 1965. But since then, neither any position has been taken by the respondent nor any compensation for the requisition of the property was paid to the petitioner or her predecessor in spite of the repeated demand. The contents of the petitioner is that by virtue of a compromise decree out of the plots under requisition, aforesaid plots was number so and so were allotted into her favor. The petitioner has accordingly prayed for issue of an writ in the nature of mandamus commanding the respondent to the collector to release the release from requisition plot numbers, these two plots mentioned here. The respondents have neither filed opposition. It appeared that the said two plots have been recorded in the name of the petitioner in the revisional record of right. From the information slip, the annexure D to the petition, it appears that the certain lands appertaining to plot number 118 was requisitioned under the provisions of the said act. Having heard the submission made by the learned advocate of both sides and on going through the material on record, it appears to me that in this case the respondent do not appear to have taken steps to complete the requisition and or acquisition proceeding. The government cannot be allowed to retain a property by making an order of requisition, but without taking any further action for completion of the proceeding for an unlimited period of time. Since the government has not even taken possession of the property in question, it will be obviously follow that the reason for which the requisition order was made no longer exists. Under the circumstances, government should be directed to release the property from requisition and pay compensation thereof within a period of reasonable time. For the aforesaid reason, I dispose of the writ petition with the following direction. The respondents are directed to release the aforesaid plot from requisition within period of 2 months from the date of so and so, from the date of communication, and pay the compensation. This was the order passed. The requisition notice or gazette notification was passed at page 74. Lordship will get it in 1997. That de-requisition as per the order of court was passed, and de-requisition notification of 2015, my lord, ultimately possession delivery notification at page 83. It is vital. Lordship can look at page 83. Page 83 is the third paragraph. Now, therefore, in excess of the power under subsection 1 of section 7 of the Act, Governor is pleased to release such land as described in the schedule from requisition. And schedule has been given, my lord. My area is Bhagavanpur. Bhagavanpur, so many areas have been, my lord, released because they were the part and parcel in the said writ petition. But so far I am concerned, my lord, our lands are still lying unutilized and in a requisition status. We are not getting any, even we are not interested or
We
getting
are not
any.
part of this released order.
We are not part of it. So, my lord, my title to the property is undisputed. I have, my lord, lordship kindly come to page 73. My predecessor in interested, my lord, he has a land, my lord. These two lands, 320, page 73, record of right, 320 and 366, Velayati land. My lord, I am at the hand of the government, my lord. Let them take a reasonable stand in this matter as that of the other lands.
Yes, Mr.
Hey, Dada.
You received a copy.
No. এতগুলো কাগজ দেবে?
Not considered, yes, we all know. Then next what?
Next one, I kindly direct the authority to consider and pass a reasoned order, whatever they wish to regarding
In
this.
terms of the earlier notification,
Earlier order of this court, my lord.
as well as the notification.
Grateful.
But earlier order was in respect of two plots, which is not in respect of these plots. Earlier plots were involved, two Bata dags, 318 Bata something and 318. Subsequently, one order was passed in respect of those two plots. But this de-requisition notification of 2015 Yes, Mr. Bhattacharya's client can take this plea of 2015 notification. That is at page 83. Take the, kindly direct the authority to take a decision in tune of this notification.
Grateful, grateful.
Supplementary affidavit submitted on behalf of the petitioner and status report submitted on behalf of the respondents are taken on record. Paragraph for learned counsels for the parties. Paragraph. It is not in dispute that the petitioner is the recorded owner.
Petitioner's predecessor was a recorded owner and we have inherited the said property. Durlabh is no more there. Durlabh died.
Predecessor of the petitioner was the recorded owner of the plots in question.
Plot number 320.
Plot
Kindly.
numbers being
320 measuring 3.87 acres and 366 measuring 1.66
plot
acres.
number 320 measuring
3.87 acres.
3.87 acres and
Plot number
320. 320 measuring 3.87 acres and 366
measuring 1.66
acres. And the petitioner has acquired title and possession in respect of the same by way of inheritance.
Kindly, do not mention about the measurement because the notification does not reflect
not
the
the notification.
quantum of the area which was required.
In gazette notification, my lord, I have mentioned.
আপনি তো ল্যান্ড রিফর্মস এর মিউটেশনটা থেকে বলছেন, তাই ওইটা
সবটা হয়নি
না, এবার পার্ট হলে তখন কিভাবে দেবে?
আমি ওনার অফ দিস ল্যান্ড বলেছেন জজ সাহেব, অ্যাকুইজিশনের কথা বলেননি।
The said plots along with other plots were requisitioned
in LA case number 42 of 6667.
Case number 43 of 66/67.
42 of 6667.
It's 43, not
What
42.
it is in that notification itself, page 3, and it is written there in their note also, it is 42. In that note given to your lordship,
it's 42.
So it's 42 or 43. The notification says 43.
LA case number mentioned here.
Notification, we should rely notification.
Notification is 43. 43 of 66/6. কি বললাম?
No, Bhagavanpur B. Bhagavanpur is in the said notification B. Bhagavanpur is LA 20 of 42 of 1966-67. I am Bhagavanpur.
In your supplementary affidavit, where is it? It's not there.
In my instruction, kindly come. First, second, third.
LA case number 42.
Yes,
that is exactly
42.
42.
42 করুন। কি বললাম ওটা সেন্টেন্সটা শুরু করেছি কি? And subsequently, some of the plots were released in exercise of power conferred under section 7 within bracket 1 of the East Kolkata Wetlands within bracket conservation and management bracket closed Act, 2006. However, the plots in question were not considered by the authority In the notification issued on 19th February 2015 for release of some of the plots. Stop. Some of the owners filed a writ petition being CO 14156 within bracket W of 1991 claiming release of the plots involved therein on the ground that neither possession was taken, nor any compensation paid by the authority. Stop. By an order passed on 30th January 1992, a coordinate bench of this court directed the respondents therein to release the plots involved in the writ petition from requisition within a stipulated time frame. Stop. Pursuant thereto, a notification was issued by the Land and Land Reforms Department, LA branch on 19th February 2015, releasing some of the plots from requisition. The petitioners appeared to be similarly circumstanced with the owners whose plots have been re-requisitioned/released with a notification dated 19th February 2015. Paragraph, in view of the above, this court is inclined to hold that since the land of the petitioner one petitioner is yet to be released, the concerned authority, respondent number, the Joint Secretary has issued this.
Yes, I was about to say this. When a 2015 notification was issued by the Joint Secretary, though Joint Secretary is not made a party. So, kindly, grant them liberty to add Joint Secretary and then pass an order upon the Joint Secretary to consider.
Yes.
No, sir.
Reforms Department, LA branch, Nobanno, Howrah, be directed to consider release of the plots in question in favor of the petitioners in tune with the notification dated 19th February 2015, within 1 month.
Within couple of months.
Within 2
Everybody
months.
is on.
Hearing not necessary.
Hearing is necessary. Hearing is necessary because of the fact otherwise handed back to them.
Within 2 months from the date of communication, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance. Disposed of which line? একদম শুরুতে না একদম শুরুতে করুন on prayer of the petitioner, liberty is granted to implead the
Joint Secretary.
ওখানে ওই যেখানে এর আগে বললাম না, যেখানে ওখানে বিইং দ্য 8th রেসপন্ডেন্ট হিয়ারিং করবেন এর আগে, হ্যাঁ তো যেখানে ডাইরেকশন দিচ্ছি, বি ডাইরেক্টেড না না বিইং দ্য 8th জয়েন্ট সেক্রেটারি বিইং দ্য 8th রেসপন্ডেন্ট হিয়ারিং, 8th রেসপন্ডেন্ট হিয়ারিং, তারপর বি ডাইরেক্টেড, হ্যাঁ ওখানে be impleaded as the 8th respondent in the writ petition. Stop, the cause title of the writ petition be amended accordingly. Paragraph, since the 8th respondent is already represented, comma, further service of notice upon him is dispensed with.
Well, only one prayer, my lord, I am making. The petitioner is self, son, and other legal heirs. Power of attorney has been given to him to prosecute. Petitioner and other legal heirs. What should be? Disburse the hand over the land to the real owners.
Being and the petitioner and others have acquired that.
Other legal heirs of the original owner.
Stated, have acquired as legal heirs. Then by way of inheritance. Last is যেখানে বললাম ওই hearing the petitioner and the other legal heirs. As stated, all concerned. So that includes
As well as well as.
And other legal heirs. Disposed of, it's applied. Next.
Perfect. State. But I'm for the petitioner. I'm for the state. At the first occasion, I could not effect the service. Thereafter, my lord, the service has effected. But my lord,
Only state respondents or there are private respondents?
there are private respondents, my lord. And my lord, in respect of my lord, the private respondent, my lord, the service was not complete. Pursuant to my lord's direction, we effected my lord, the service.
Several private respondents?
Yes, my lord. Only the 14 and 18. Your lordship will kindly peruse my lord's order dated 5th of March. The lordship directed, since service upon the respondent of 14 and 18 is not complete, let the matter stand over till the 2nd of April. So 14 and 18. 14 and 18 এর নামটা বল না ছোট্ট। প্রসেনজিৎ গুড়ে, পূর্ণেন্দু মাইতি।
You've sent it to one Purno Chandra Maiti.
Yes, my lord, and thereafter, my lord, there was a letter given by the postal authority. We corrected the name and sent it, my lord, to the right person. And Prosenjit Gure is Prosenjit Guria.
This is Purno Bindu Maiti.
Yes, my lord, there was a blood on the reverse of the envelope. My lord, there was a blood. His correct name was not given by the postal authority.
So actually,
it is Purno Bindu, my lord. We made a mistake.
So you have to make the necessary corrections.
Yeah, I will take leave from your lordship to correct. I'll take leave.
Purno Bindu.
Yes, that is what the postal authority had, my lord, given an endorsement on the reverse of the envelope, and we send it to him. He has received.
So you need to make necessary corrections in the cause title.
Blood, yes.
Yes. What's the matter?
In respect of Lord, the surname of the respondent number 14, and in respect of name of Lord, the respondent number 80. But I am the Borgadar in respect of Lord, a particular plot of land. My name is recorded in the record of rights. Now, Lord, just abutting my land, Lord, there is Lord, a waterway. On the waterway, there is an embankment. Now, Lord, on the embankment, there is an encroachment. Now, Lord, on the basis of the encroachment, the photographs are annexed before your lordship, but I gave a complaint to the authorities.
Now, my lord, the governing statute is, my lord, the Bengal Embankments Act 32A, my lord, which says that, my lord, the engineer is to look and take for removal of unauthorized encroachment. After giving, my lord, the letter, my lord, no steps have been taken by the authorities, and I am before your lordship. Now, my lord, your lordship will kindly see, my lord, the photographs, my lord, that I have annexed, that will, my lord, amply speak about the fact about, my lord, the situs of the property, page 22, 23. 22 no 23. But page 22, 23.
Right, yes.
But
This
the
is
look,
construction that is being made.
yes, on the embankment. Ainta de.
Where is your complaint?
It's blood, your lord, page 35, my lord. I'm sorry, my lord, it is 34. It is 34.
34.
34, my lord. না 35. 35. তোরটাতে 35.
33 actually, not 33.
33. I'm sorry, my lord.
33. Yes, let us hear the state.
My lord,
Have you considered this representation?
consider representation, subdivisional officer already write a letter to the officer in charge on 23rd November 2023 regarding this unauthorized construction removal. My lord, may I hand over this instruction? Annexure, my lord, 2. There is a letter dated 23rd November 2023 by the subdivisional officer to the officer in charge, Shampur Police Station.
Instruction.
A GD has been lodged.
GD has been lodged.
Then?
Then, my lord, they have not taken any steps on the officer. I'll kindly direct the officer in charge to take.
But apart from that, my lord, there's a provision, my lord.
Yes, the GD will not really help. There is also a request for physical demarcation, so let that be done within a stipulated time frame.
But that they are constructing on an embankment, my lord, that is not that is without any doubt.
No, if they want to demarcate, let them do so.
I'll kindly direct.
The demarcation is in respect of, my lord, the property which, my lord, they own. But in respect of the embankment, my lord, there cannot be any construction. So it is my case that they are constructing on an embankment.
Adjacent to the embankment, yes. And they want to demarcate that property itself. So let them do that. And then
And-
consider your representation. With
And, my lord, if there is a construction on the embankment, your lordship will direct, my lord, in terms of 32A.
Yes, yes.
But-
You've stated that in your representation.
Yes, I have stated that in the
1882 Act.
1882 Act. Yes, that is, my lord, my prayer even. My lord, at page, my lord, page 37, 36. It is stated that under section 32A of the Bengal Embankment Act, 1882 confers ample power upon the engineer as defined under the Act or any other person duly authorized by him in this behalf to remove, dismantle or demolish any building, obstruction, encroachment of any other construction which in the opinion of the engineer is likely to interfere with the counteract or impede any public embankment.
Have you implemented the engineer as a party?
Yes, my lord, Lord, the engineer, my lord, we do not know who is, my lord, the engineer, my lord, authorized under the Act, but my lord, we have, my lord, 3 and 4 is, my lord, the Irrigation and Waterways Department, under whose, my lord, jurisdiction, my lord, the waterways, my lord, are falling.
Who should be the authority to consider?
My lord, the joint secretary. The reservoir number 3.
Very well. Let them consider within a stipulated time frame. Affidavit of service filed by the petitioner. And statement of fact submitted by the state respondents are taken on record.
Conference at time.
Paragraph, none appears for the private respondents despite service. Paragraph. It is contended on behalf of the petitioner that the petitioner is the recorded Borgadar in respect of 1.27 decimals of land in LR Dag number 3006, Khotiar number 535, jail number 109, Mouja Dinga Khola, Dinga Khola, district Howrah. Stop. The private respondents have raised unauthorized construction on the embankment adjacent to a water body adjoining the plot of the petitioner, thereby obstructing his egress and ingress. The petitioner submitted a representation in this regard before the concerned authority on, what is the date of your representation? Blank.
My lord, 6th of October 2023.
Where do you get it?
My lord, the last page of that representation.
That is the demand of justice.
Yes,
The representation, the previous
but
one.
that is not the representation. my lord. And prior to that, my lord, there is one at page 32.
Yes, page
That-
33 in fact.
Page 33.
Yes, no date.
There is no date here. There's no
It's
date.
annexure P4.
Yes, but
within
your
that-
lordship may kindly, my lord, direct not the page 33. That is more comprehensive.
That's, your paginations are not.
My lord, I
direct-
understand, lord, even my pagination I heard, lord.
Cannot direct consideration of the demand of justice. It has to be the representation. Do you want to file a comprehensive representation?
But that will
can
be
do.
better
You can.
because yes.
The petitioner seeks to submit
কি
a
পাতাগুলো কেন
comprehensive
মিলছে না বাবা?
representation before the concerned authority in the praise for a direction upon the authority to
আশ্চর্য ওর
consider
পাতা
the representation at the
তোর তো
earliest.
মিলছে না
Paragraph, learned counsel for the state respondents submits that pursuant to the
Okay.
representations submitted by the petitioner, a general diary has been lodged by the subdivisional officer, Sheechberia, SEIJ, Sheechberia Irrigation Subdivision, before the officer in charge, Shampur Police Station, on 23rd November 2023.
আধ ঘন্টা হয়ে যাবে
The subdivisional officer has also requested the block land and land reforms officer, Shampur-Roman 1 block for demarcation of the plot in dispute / embankment by a letter issued on 24th November 2023. Stop. The demarcation is yet to be made. Paragraph, in view of the above, this court is inclined to hold that since the block land and land reforms officer has been requested to demarcate the plot in dispute in order to ascertain the alleged unauthorized construction made therein, the BLLRO has also not been made a party.
Yes, BLLRO is made a party, my lord.
No, where?
My lord,
It's the DLNLRO, not.
BLLRO is party.
Will you please add the BLLRO as a party so that
Very
I
well.
give him a direction?
I'll-
The block land and land reforms officer, being the 19th respondent hearing, be directed to demarcate the plot in dispute upon service of notice upon all concerned, including the petitioner and the private respondents, and submit a report to that effect before the third respondent within 1 month from date. Stop. Upon receipt of the demarcation report, comma, in the event encroachment upon
officer.
the embankment or any portion thereof is found, comma, the third respondent be directed to initiate proceedings. Proceedings should be under the Bengal Embankment Act.
Yes, 1882.
Is under the Bengal Embankment Act, comma, 1882, and take the proceedings to its logical conclusion within 2 months from the date of receipt of the demarcation report, upon affording reason hearing to all the interested persons, including the petitioner and the private respondents, comma, in accordance with law. Disposed of which apply?
May it be under 4 months because the election is on. If my lord,
Demarcation within 1 month
1 month,
and the consideration within another 2 months.
within 3 months we was.
3 months. 1 month and 3 months. একদম শুরুতে করুন, on prayer of the petitioner, liberty is granted to implead the block land and land reforms officer, comma, Shampur -Roman 1 block, comma, Shampur, comma, Howrah, as respondent number 19 in the writ petition. Paragraph, the cause title of the writ petition be amended accordingly.
Lord, liberty,
To the necessary correction.
but liberty to correct, Lord, the names of Lord, the respondent of 14 and 18. The surname of 14 and name of 18.
It's granted to the petitioners to correct the name/surname of respondent numbers.
14 and 18.
Surname টা আগে করুন, name টা পরে করুন. Surname/name of respondent number 14 and 18 in the cause title of the writ petition. এই দুটোর পরে করুন, cause title be amended accordingly.
জানিস তো কিভাবে করতে হয়? Leave granted by Honorable Justice বলে।
Since the 19th respondent is represented, comma, further service of notice upon the said respondent is dispensed with.
Lordship.
Because he is
Very
representing.
hastily. I'm grateful, my lord.
Miss the bus. You are appearing for? Only 15, except 15.
15 টা কে রে?
Except respondent number 15 responsible.
I'm grateful.
Deeply up.
এটা কারেকশনটা করে কারেকশন
But I am for the petitioner.
Appearing for the first.
Epidemic, no, my lord.
Sir?
After service. Lord, I sub copy by hand. This is the epidemic of service. By hand, my lord, I sub. Kindly come to page 17 and 18.
Give me a minute.
Yes.
Give me a minute, please. Who is the contender? Where is the service?
My lord, top, my lord, stamp, my lord.
Served at the department, not to the individuals. This is a contempt application.
Yes, my lord, I served, my lord, no,
You
kindly.
have served the department.
My lord. Kindly come to Sri Dipendu Das, IAS Director, Public Vehicle.
You have addressed to.
My lord, at the top, my lord, 11/3/2024. 11
Yes, it is received by the public vehicles department, contents not verified.
My
You have to serve individually to the contemners.
My lord, I served the copy to the Dipendu to the first alleged contender, my lord, at the office of the PBD, my lord.
You have to serve in person, you're aware. This is a contempt application, it's a personal liability. So you have to serve the person, not the office.
My lord,
You have addressed
yes.
them, but you have served at the office. The department has received it and they may not be aware of it.
My lord, normally, my lord, the receiving counter accepted all the
Not
applications.
the contempt applications. Contempt has to be served on the person. So please serve and come back.
My lord, next page, my lord, Sri Anupul Sarkar and Devashish Boitro, all are received by the
Same
corporation.
thing. It's all received by the department, not by the
The receiving section is accepting accepting
They are
the
personally liable. So receiving, you cannot serve the receiving section, you have to serve them by name.
But then I shall have to sub by speed post.
Yes, yes. They have to receive it. Because they may not even know, isn't it?
But normally, my lord, the department, the receiving section received it and sent it to the.
In all cases, but not in contempt applications.
My lord, I shall sub.
Please take this back. Since service upon the alleged contemners is not complete, comma, let the matter stand over till 18th April. Oh, 18th is a Thursday. 19th April.
Clear, my lord. I shall sub tomorrow, my lord. By speed post.
15th April.
By speed post, my lord, kindly.
15th April.
By speed post.
Yes, that is the usual practice.
Next matter is same.
Next, same up. Next. Same order.
Well, at 778, my lord, I'm for the petitioner. My lord, your lordship has passed an order on 6th of February of substituted service. Following order 5 rule 20 principle. My lord, that was paper as not yet complete. One part has been completed. But kindly grant us some more time and keep this matter in the month of May. So I'll file evidence service with the DSP. My lord.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear. Let the matter appear under the same heading on 10th May.
My lord.
Next.
779, my lord, Ashim Hatia is appearing on behalf of the petitioner, my lord. He could not come to the court, some personal difficulty, my lord. I am paying for only not.
Prayer of the petitioner, the matter is adjourned. Several adjournments have been granted. Who is appealing for the respondent? Where is your report in the form of affidavit? In the form of affidavit?
My lord, I am appearing, my lord.
Yes.
Sorry, my lord.
Please serve a copy to the petitioner. Report in the form of affidavit submitted on behalf of the respondents is taken on record. Paragraph on prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 10th May. 10th May.
My lord, my lord.
I have received.
Next. Yes, respondents?
I am appearing.
Yes. Mr. Mukherjee, you wanted to use an exception. You have used it. Huh?
Yes, I also served the copy at Nina.
Lordship kindly fix the next week at any day, my lord. I shall not I shall not go through the exception. That is the problem.
On prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 12th April.
Your Lordship kindly appreciate one thing. This has been served upon the respondent on 27th of February. Your Lordship kindly see.
Mr.
And-
Debra is asking for an adjournment. Come
Okay,
back
so
next week.
that means it's so 1 week. Your Lordship kindly see. If it is then 27th February, I have served the exception. We are in April.
Since 2017, he is waiting. Now he is now asking.
Come back next week, 12th April.
My lord.
Mal.
Rajiv, 12th April.
Please, your lordship.
I am appearing, my lord.
But in this matter, this is the RTA Purulia. But I applied for a permit, my lord, for the interregional permit from X to Y, X to Z. So in the hearing, my lord, the RTA Purulia granted me a permit from X to Y instead of X to Z. That they cannot do. But according to section 71, choice of the route completely depends upon the petitioner, applicant. Number two, my lords, according to section 80, an applicant can apply for a permit at any time unless the route is notified under section 71 3D. This route is not notified route. And not only that, the RTA Purulia has already issued more than 100 permits in respect of the route having a distance, longer distance. But no
That is not the issue, my lord. May I submit I took instruction, my lord. Here, my lord, this is the main problem, my lord. Petitioner route is, my lord, totally congested. There is no parking place. He is speaking, my lord, regarding Lalpur. Lalpur, there is no parking place. Only small vehicles are operating. No parking place. If the petitioner chooses to, my lord, any parking place is there, he applies, I shall consider my direct request authority. There is no parking place.
Where?
Specific instruction. Lalpur, there is no parking place. It's a congested area.
Whereas, my lord, I have been granted.
That is not the reason given by you.
Yes, my lord.
The
That is another. But this, my lord,
I took instruction in that regard.
Cannot
So
be.
why his permit was not allowed? Then,
Cannot
my
be
lord, they
bifurcated.
have stated, they have stated by statement, my lord.
They
that-
cannot state anything beyond what they have recorded in the resolution. In the
My lord.
resolution, it is only stated that since the route is very long, it cannot be granted.
That
But
is-
you
that
have
is-
granted permits for longer routes.
That is, my lord, that is, these are
Be considered. Now you're bringing up a fresh case which cannot be considered.
no. That is why, my lord, his route has been changed due to, my lord, Kesargarh. There is
Cannot
a
change.
parking place, Kesargarh.
Authority
But this
cannot.
parking place cannot be taken into consideration at all. Because that was not your reason given in the resolution, in the
Lordship may direct to
visit.
revisit the issue, that is better, my lord. Direct revisit the issue.
My vehicle is even idle, my lord. There is no reason, my lord.
Within 1 month.
My lord.
Within 1
Revisit this.
Well, there is no impediment in the eye of law to issue permit, my lord, in respect of the route what I have paid for.
Where there is no parking place, how can it?
This is parking place is not the
This parking place
That point has not been taken
not
by
been
the
taken.
board at all.
they will take, my lord. Now they will take. Now they will take, my lord.
Revisiting the issue will not help, Mr. Debroy.
Now they will take.
I'll give a direction to grant permit.
Yes, my lord. This is your lordship.
Then in that case, lordship, kindly allow me, my lord, next week I shall
why,
physically come back. No. Then in that case, my lord, I shall file one affidavit so that lordship
what?
when my lord, report. I shall file a report.
How can you improve on that?
The report
Because
I can.
the resolution doesn't speak about.
That is why, my lord, I am submitting receipt, your lordship, my lord. Lordship, kindly direct the revisit the issue. Because the ground taken by the RTA secretary is not tenable. It's not tenable in the eye of law.
So when the ground is not tenable, it has to be allowed.
No, it
There
has.
cannot be any
is
other
not
option.
when there is no route at all, motorable route is not.
In this particular route, my lord,
motorable, particular small vehicles are operating, not by a long vehicle.
Since
That is
all
the.
this has not been taken up by the authority, you cannot bring up new issues at this stage. The only point taken was it is a long route. You have granted permit for routes which are longer than this. So there is no impediment in granting permit. I'll give a direction for grant of permit. Because if I send it for revisiting, the authority will take these two issues again in their resolution. Simple. So I cannot give that leverage to the
Kindly
authority.
allow me to file one affidavit, short affidavit.
My lord, affidavit?
Report
After
in the
5
form
days.
of. No, I took instruction. Last order, I took
5
instruction.
days. Is there any necessity?
I leave it to your lordship, my lord. I can't say anything, my lord. I leave it to your lord. I can't say.
I'll keep it next week for a report in the form of an affidavit. Then I'll pass necessary orders.
As you lord.
My lord.
My lord, only one submission, my lord. On this particular route, Lalpur to Ropo, vehicle is flying.
Small vehicle is flying. Small vehicle.
One vehicle is flying. My vehicle is the second, would be second one.
One
So
vehicle is flying.
if a vehicle has been flying, the question about the no parking place does not arise at all.
Learned counsel for the respondents submits that the authority could not grant permit to the petitioner in the route Lalpur to Ropo since there is no parking space at Lalpur.
My lord.
Paragraph learned counsel for the petition, learned counsel seeks to submit a report in the form of affidavit in this regard. But counsel for the petitioner submits that one vehicle is already plying from Lalpur to Ropo, the said submission being admitted by learned counsel for the respondents.
I don't know, my lord. I don't know about buying.
You have said that there is one vehicle flying.
One vehicle I can't say. Only, my lord, small vehicle, small. Small vehicle, small, not bus.
Parking space and only small vehicles
My lord.
are being applied in
this route.
Let the matter appear under the same heading on 12th April.
Deep law place.
12th April. Next.
Or may I have it only since the last chance, because only 6 days has been gone.
It's come. Group 7 matters are not many.
Lord, I appear for the petitioner. My lord.
Yes.
My lord, the petitioner had, in this case, my lord, the petitioner had sold.
12th April, I think, my lord, 12th April is a holiday, my lord, for Eid.
11th is Eid. 11th is Eid.
State government has declared, my lord, 11 and 12, both.
State government declares many things. The court doesn't declare.
Well, let it be on 16th, that is better. 12th, that is 16th.
16th April.
That is better. Otherwise, holiday and
16th April.
I have no objection.
12th is jaga 16th April.
My lord.
16th April. Yes, 782.
782, my lord, I appear for the
Have you served?
petitioner.
Where is your
My lord,
service?
my lord, this 2 affidavit of services, my lord.
Please show me.
My lord, the respondent number 3 and 4 had been served. It had been returned back. Your lordship had directed to serve again. I have served again, but again it has returned back.
Appearing for the state, Mr. Debra.
No, I am not appearing.
Who is appearing? You served 3 and 4?
I have served again 3 and 4, but it has returned back. My lord, probably respondent number 4 has changed their place of business. That is the only available address.
So you have to
My
find
lord.
and serve. You have to either serve or expunge the name. You cannot expunge.
I
probably.
cannot expunge probably.
So you have to serve and come back? Yes.
My lord, the difficulty is I do not know about their whereabouts now.
You have the website now, you have the net now, take advantage of that.
I shall
If
do
it's
it.
a company, you'll have their address at the website. Affidavit of service. Since service upon the private respondents is not complete, let the matter stand before you. 6th May.
6th. Affidavit of service.
No, I have recorded, let it remain.
Well, in this matter, I am appearing on behalf of the petitioner. Well, of the
Respondent.
on 6th March.
I am appearing, my lord. 783, I am appearing.
Matter was filed on 6th March because the service is not complete. For this reason, my lord directed to serve the copy again. So, my lord, I have served some 2 affidavit service.
Have you been able to serve?
Yes. The private respondent number 5 and 6.
Yes.
Both have been delivered. Both have been delivered. Can you check? Initially, my lord, respondent was 6. Copy was delivered.
Item delivered to sender.
Send out that again, my lord, second affidavit again accept. They are accepted. Delivered. Yes. For this reason, my matter was that job. The last page, man. And also hand service also there. Both. Third attempt, my lord, accepted. Third attempt.
Yes, what is the matter about?
All matter, my lord, we are holding a permanent contract states carries permit on modified road. My lord, page number 28. Our route is 28 and 24. 24 and 28. My lord, we are specifically complained against the respondent of 5 and 6. Now, can you see the page number 32? When annexure 1, our permit, copy of permits. Page number 32.
Yes.
My specific complaint against the respondent number 5.
that is route against the route number 39A/2. Their route my lord picnic garden to Howrah station. As per my lord permit condition, my lord, they will complete the entire alignment of the road as per section 72 subsection 1. The vehicles shall be used on a specified route assigned in the permit. Now they next page number 33. I have given the route map from Howrah station to picnic garden. Total kilometer 13 kilometers and only 18 kilometer, but it is the 13 kilometer. Now kindly see the page number 34. Another map, they are flying only Howrah station to Mola Mode, only 6 kilometers, 8 kilometers. My lord, illegally flying at the top, my lord, illegally from Howrah station to Phillips Mode. Total distance 8 kilometers. Out of 13, only 8 kilometers is flying. Next page, page number 35, Annexure P4. Another route, my lord, route number 39 to 39B. Their route, my lord, Sapurji Palan Complex to Howrah Maidan.
This is whose route?
These are the route, route. But they are flying the vehicle, but some vehicles are flying. Kindly see the map, route map 36, total kilometer 26 kilometers.
How are you affected?
Our affected, my lord, they are flying on my route. On my route. Sialda to Howrah station, our route. My lord, route number 39B, their route Howrah to Sapurji. This is the entire route, 26 kilometers. Next page, page number 37. We are flying only Howrah bus stand to Siptola, 6 kilometers. Out of 26 kilometers, only 6 kilometers flying. So we made a objection before the chairman, director, the regional transport authority, Kolkata region, also secretary, page number 38, and specific complaint against the vehicle number, page number 39. Last paragraph, I have given in case of my 39A route, A/2 route, only 10 vehicles are against complaint. And my lord, page number 40, last paragraph, 239B, we are out complaint against the 4 vehicles. Now, after receiving, my lord, this complaint as well as the petition, after receiving this petition, my lord, the president secretary of route number 239AB and route number
24.
Route number, my lord, 39AB, they have subbed a letter. Not only me, advocate on record, they have also informed to the director and vice chairman and the secretary, Alliance Service. Mentioning the 4 permits as well as 10 vehicles. They have stated in their complaint, in their letter, that those permit holders are not the members of our association. They are flying in violation of the route condition. They are flying vehicle up to the Sialda. So if their permit is cancelled, we have no objection. Can you see the letter? We have read the objection. That objection can be direct. My objection can be considered. At the time of hearing, I shall place all the documents. All those documents are available to their authority. Only direct the authority Annexure P5, our objection. Kindly direct the authority to consider this representation, nothing else.
This is not required to be recorded.
No, not necessary. We shall just have placed for you sort of information.
Yes, Mr. Devray.
Page number 38.
Let his objection be considered by the authority upon giving hearing to all the parties,
yes,
including the affected, my lord, private respondent also.
Of course, yes. The petitioners are stage carriage operators. In the combined notified route number 24, comma 24 capital A and 24 capital B. Stop. B, comma D and 28 and 28. Stop. 24, 24A, 24B and 28. These are your rules. The petitioner's grievance, petitioner's grievance is that the private respondents are plying their respective vehicles by curtailing a substantial portion of the routes allotted to them. In contravention of Section 72 of the Motor Vehicles Act 1988.
88.
The petitioners submitted an objection before the concerned authority in this regard on 16th January 2022, which is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the objection at the earliest. Paragraph. Learned counsel for the respondents, the state respondents submit as a affidavit of service and non-case for the private respondents despite service. Paragraph. Learned counsel for the state respondents submits that who should consider?
Two. RT board, yes, it will be.
RT board.
Second respondent be directed to consider the objection in accordance with law. Paragraph. In view of the above, the disposed of directing the second respondent to consider and dispose of.
Third. Mr. Khan, third.
Third, it should be third.
Yes, yes,
It should be third. Yes.
Third, second, the third.
Yes,
Directing
third.
the third respondent
My lord.
consider and dispose of the objection submitted by the petitioners dated such and such within 1 month.
Yes, no, 1 month.
Some not required, my lord. Sometime is
6 weeks. Within 6
Yes,
weeks
ma'am.
from the date of communication of this order,
deep level.
upon affording reasonable opportunity of hearing to all
All the hearing operators.
all concerned, including the petitioners and
Yes.
the private respondents,
Ma'am.
in accordance with law.
Right.
Paragraph. The decision taken by the authority shall be communicated to the petitioners within a week thereof.
Madam.
Deep level.
I'm for respondent number 5 and 6 with Mr. Chok.
Petitioner, your appearance.
I'm for the petitioner.
Yes.
Holder have a contact carriage permit and flying an auto. But the auto rickshaw is not having 15 years of age. The petitioner wants to replace the auto by placing a new auto. But he made application before the authority. Now, the secretary RTA said that the portal is not allowing him to make correction in the system. Your Lordship, kindly see. First, your Lordship, kindly see. Annexure P1, my lord.
Yes.
The date of registration of the vehicle, 2nd November 2007. Now, my lord, upon 15 years of age, my lord, the vehicle is needed to be replaced by a new vehicle. Thereafter, your Lordship, kindly see, my lord, I have made an application on annexure P2, page 15. Now, my lord, I have made this application before the authority for replacement of my vehicle by a new vehicle. Thereafter, you also kindly see page 16, annexure P3.
This has been considered by the authority?
No, this has not been considered. And my lord, one vital thing, after filing my writ petition, the secretary RTA, your lordship kindly see this is very vital. The secretary RTA himself written to the director transport department that the not only me, my lord, several my lord, motor vehicles holder who is insisting to replace the old vehicle by a new vehicle, they are suffering problem due to this. My lord, they are not allowing. My lord, my prayer before this, my lord, let the director transport directorate government of West Bengal, my lord, he have filed report what step he has taken, because the regional transport officer South 20 Parganas, my lord, specifically says that, my lord, may I please find the enclosed letter of C. Shumen Bhattacharya, land advocate, Calcutta, such and such, regarding cancellation of hypothecation and scrapping of vehicle of such and such. The matter was communicated to you earlier by my office memo number such and such, dated, and through an email dated 19/12/2022. Some other owners also facing alike problem to scrap their vehicles. You are requested to take initiative to resolve this issue in general at the earliest.
My lord, that has not annexed, my lord.
After filing the writ petition, my lord, I have got this copy, my lord, it is.
So come back with a supplementary affidavit.
My lord, one thing I am submitting before your lordship, he wants to replace the old vehicle, but he wants to scrap the old vehicle to new. But he, in his prayer, he submit his prayer, my lord, kindly page 10, his page 10, my lord.
Page 10.
Yes. Replacement order in respect of scrap for scrap them. He never said anything about scrapping. Only to raise. Sorry.
That is the main issue.
Scrapping all.
But that my prayer is before the authority to not.
Your prayer is only for replacement.
Only replacement.
Yes, by allowing in place of vehicle number such and such, that is the old vehicle.
You want to place the new vehicle. That's
Yes,
but
the vehicle, the old vehicle is 15 years of age. But I want to place one new vehicle in respect of old vehicle. I am yes, because they have to issue scrap order and also allowing me to place the replacement.
These are two different issues. One is replacement, one is issuance of scrapping order.
When the scrapping order is issued, when I want to place a new vehicle, the system is they are going to they are scrap my old vehicle and simultaneously they allowing me to file to place a new vehicle. Scrapping of old vehicle, I have a permit. Permit is valid to 2026. Now this vehicle is old. I cannot fly.
Replace your vehicle.
Yes, replace your vehicle. Simultaneously, the permit cannot be empty. I have to place a new vehicle.
Yes, no, the permit, if you do not place a new vehicle, your permit is
First of all, they have to allow me to scrapping my vehicle.
Order
not necessary.
That is the kindly see there,
আমরা কি কনসিডার করেছি?
Kindly see.
They will allow you to replace your old vehicle by a new one. If you want to scrap your vehicle, you have to make a further application asking for permission to scrap your vehicle. They'll tell you the necessary procedure. These are two different issues. Replacement doesn't automatically mean scrapping. You may keep the vehicle with you.
My respectful submission before lordship, if they are not allow me to scrap my old vehicle, the vehicle is remaining in the permit, how can I replace?
Scrapping the old vehicle, please show me. You have only asked for replacement.
Yes, that is automatic, my lord, because the
not automatic.
Because the vehicle is by his age, scrapped 15 years.
They have some sentimental attachment with the vehicle, and you
normally I cannot fly because
a specific prayer for scrapping your
not. Yes, I have also played for your kindly see.
You've only asked for replacement.
Page 10, my lord. Only replacement.
Yes.
Yes, my lord, I have.
Replacement and scrapping are two different things. It is not automatic.
But the vehicle, my lord, by operation of law, cross 15 years of age.
So you can get it replaced.
Yes.
Scrapping is something else.
But your lordship kindly will pass order for replacing my vehicle.
Yes, Mr. Sen?
So far, replacement is concerned, that is, my lord, the jurisdiction of the permit issuing authority.
Yes, yes.
And so far, the scrapping and other thing is concerned, that is with regard to the domain of the registering authority. Because once a vehicle is registered, then, my lord, the registering authority, it has to be, my lord, apply before the registering authority for the purpose of, my lord, the cancellation of registration, scrapping of the vehicle, my lord, because the cancellation of registration, sometimes it requires, after the, my lord, the validity of the registration ends, or if it comes, my lord, under the statute, that one cannot ply the vehicle on road any further. Now, my lord, that application for scrapping and or cancellation, it should be, my lord, at a time. Scrapping and cancellation of registration should be before the registering authority. And in presence of the, my lord, the agents or, my lord, authority of the registering authority, that should be done.
But there is no such.
But there is no such, and it is not a case. I think his simple case should be and would have been that the vehicle, because of the, my lord, the impediment of that, my lord, order of the division bench and the, my lord, the order of the National Green Bench Tribunal. So he is no more, my lord, able to ply his vehicle any further. So he need a replacement. Simple, my lord, 3-4 lines later, that I want to replace the vehicle because this vehicle is now, I am unable to ply the vehicle. So the authority will take step, the permit issuing authority, a replacement order should be given to him after considering his prayer. So I think, my lord, a fresh representation be made before the permit issuing authority, and that be considered by the permit issuing authority within a specific period. Only to this extent.
Yes, the private response. Anything to add? No?
But only one thing, my lord, because why I'm submitting, my lord, page 16, my lord, the mail they have sent, the mail has sent by the, my lord, RTS South 24 Parganas. You lordship kindly see what they have said. The system is one of 4th line. The system is neither allowing cancellation of the hypothecation of the vehicle nor allowing to scrap of the vehicle.
Which is not your case at all.
No. It is not his case.
Not your case.
And whatever the answer given on the basis of that.
Is, my lord, I only want to replace my vehicle.
Very good.
So
My lord, now they have sent the mail. My lord, the mail confused me.
Because of this confusion. Because of this confusion in his longest representation.
Replacement, file a short application before
Yes.
for replacement, they'll consider.
Before the permit issuing authority.
Yes.
Yes.
Let us not complicate simple
And that
matters.
provision is there under the law itself. So he has right to do that.
You can take this back.
Take
It's not part of this petition.
Thank you, Dora. Sure.
For learned counsels for the parties. It is paragraph. It is contended on behalf of the petitioner that the petitioner is the owner of an auto rickshaw.
অনেকক্ষণই আছে 3টে থেকে পাঠার ম্যাটার
Which is covered by a contract permit
অলরেডি আমার
valid
এবারে
in
already
28 August 2026. Stop. Since the vehicle has completed the age of 15 years, the petitioner seeks to apply for replacement of the said vehicle by a new auto rickshaw
নতুন আইনে
below the above, the petition is disposed of with liberty to the petitioner to submit an application before the respondent number. Respondent number, Mr. Sen?
Respondent number, I think secretary. Well, because so far this type of prayer is concerned,
It's not the party, not a party. at all.
secretary is not a party.
Malad, the regional transport authority.
No. Secretary is
Because
secretary ke party kore de.
Malad, may I leave? Can we generate?
Yes, please add the secretary.
Secretary ke party kore de.
Yes.
Liberty to the petitioner to submit an application for replacement of his old vehicle by a new one.
Malad, always, Malad, may I tell one thing only, Malad? I should have said this earlier. Malad, that consideration will be subject to the, Malad, the validity of the permit. Because the replacement, no, because the replacement, my lord, as per the statute also, during the validity period of the permit. If the permit expires,
no, that permit is valid.
Valid till 26. And subject to compliance with all required
All formalities.
fitness for the
fitness দরকার তো গাড়ি তো সেরে দিচ্ছে গাড়ি ফিটনেস পাবে না
Transport Authority,
ফিটনেস
South
তো পাবে
24
না
Parganas,
Yes, madam.
South 24 Parganas, comma, being the add করতে হবে এটা, right? Seventh respondent hearing. Within 2 weeks,
My lord.
within 2 weeks from date, stop, the ninth respondent is directed to seventh respondent is directed to consider and dispose of the application within 1 month.
Malad, since Malad, the election, Malad, they are also, Malad, the election duty. So, Lord, kindly make it, Malad, 6 weeks at least. I'm not, I do not want to say that no work they should do, but only think that a little more time, 6 weeks.
From the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, comma, in accordance with law, comma, subject to the petitioner complying with all necessary formalities in this regard.
Get
Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. On prayer of the petitioner, liberty is granted to implead the Secretary Regional Transport Authority,
24 Parganas,
South 24 Parganas, as respondent number 7 in the writ petition. Stop, the cause title of the writ petition be amended accordingly. Paragraph, since the 7th respondent is already represented, comma, service of notice upon the said respondent is dispensed with. Next.
This is the affidavit of service. My lord, I have challenged the selection process as per notification, as per resolution dated 19th of December 2023 at page 21, my lord. Page 21, agenda number 18.
Yes.
Agenda number 18, serial number 35. Only on the ground, no vacancy, rejected. Page 26 is the relevant page, my lord. Page 26, serial number 35. Resolution dated 19th of December 2023, my lord. And only on this ground, my lord, I have challenged the selection process. My lord, I raised the question whether the authority considered all the documents of the petitioner as well as the private respondents. My lord, my only prayer today, my lord, kindly ask the authority to submit a report by form of an affidavit by showing the broadsheet.
Your vehicle is at serial number?
35. Page 26.
No vacancy.
No vacancy, rejected, my lord.
Yes, Mr. Naik.
My lord, here is your report, lordship. I am giving it to my lord. Let me explain it because I am giving. Lord, report reveals nothing. In fact, I am giving to my learned friend. His only objection is because there is no reason. The decision taken by authority is not a region decision.
Yes.
That's the only.
Yes.
And my lord, we have given all the particulars and informations. Now, my lord, kindly see our report. It's a route number KB16 is a notified route as per government notification number such and such.
I think he needs to, you need to peruse the report, I think.
My lord, nothing more, my lord. 19, 12,
Hey,
20.
he can very well deal with that. No issue. What I am on is, because there are a number of applicants and everybody's case has been meticulously examined, and my lord, no, there is no question of violation of Article 14. No discrimination has been made on the basis of the financial ability. My lord, the record what was made available, my lord, selected because one vacancy. Kindly see, my lord, the route alignment number.
Let them produce the record of.
A detailed report is necessary.
Yes, my lord.
The details as to how you have considered the financial stability and.
But only
In the form of-
only thing, my lord,
report.
kindly visualize the situation. My lord,
But on earlier occasion, my lord was pleased to pass one order where, my lord,
a
the
similar matter has been
rejected-
decided. Mr. Sen was perhaps appearing. It was remanded to for fresh consideration. But I have no objection to that effect.
Issue is
I have
very
no
different,
objection.
my lord, because my client has got the offer letter, my lord. He has already made the vehicle ready for the permit, my lord.
Yes,
my lord.
I serve copy.
Private restaurant number 4, and that is the.
Lord, let me
number
clear.
36 of
No,
Kumar
only one point I beg to my lord, kindly excuse me. We have given the report. No, my lord, partial decision would be.
It doesn't say anything.
Yes.
It's a very
If that is
vague-
not, my lord can always direct authority reconsider the issue. We have
No, my lord.
we have no
There is
objection.
question of
I would like to
consideration.
see all the documents which have been considered by the authority in dealing with
Yes,
this.
yes, ma'am. Yes, ma'am.
This report says nothing. It's a very cryptic report.
If my lord desires, so my lord, I cannot say no. We'll have to.
Yes,
We'll have to, but only one thing. Kindly see, my lord.
criteria has been considered by the authority.
In next matter, my lord, I appear.
আলাদা স্যার, এটা আলাদা। হ্যাঁ, সম্পূর্ণ আলাদা।
Now, my lord, only thing is this, kindly, my lord, see the number of applicants. Then, my lord, everybody may come and say how you have rejected me. You produce all documents here.
Yes.
No, I am not saying, my lord, I'm not saying we cannot or we should not. We'll have to do. But thing is this, rehearing can be also made in their presence. They can have equal opportunity to examine the records.
It's done in their presence.
My lord.
This was
Yes.
also done in their presence.
Yes, that,
So
yes.
when you did not grant them an opportunity earlier,
They have
what is
seen.
the assurance that you'll grant?
No,
them
they have
an
already, there was no objection. This is not the point. They are not giving opportunity.
Yes, my lord,
It is not the point.
At page
Now
eight-
they are saying how we have taken decision. If they want to see the documents, they're most welcome. In the meeting, everybody presence will be there. And not all will be called. They will verify the records.
My lord,
No
kindly
issue.
come to page eight.
No issue. Now up to my lord. Now this is my
Paragraph,
submission.
paragraph 8 of my petition, my lord, page 4. And where I have stated that I have a bank balance of rupees 26 lakhs 50,000, income tax return 2022, 2023, permit copy, experience, everything. But my submission is my experience and bank capacity, financial capacity is more than the petitioner. Let them show the
I am
authority.
the private respondent. I have the
Let them show the
higher
authority.
qualification than the petitioner. So I
Correct.
got the offer letter, my lord. Let the authority
What
explain.
is the qualification that is necessary?
That is up to the department.
71(3)(d). My lord, kindly come to the
71(3)(d).
71 and 3D.
3D1.
My lord, kindly ask them to submit a broadsheet from where, my lord, if I fails, my lord, I shall get out of my.
Produce the broadsheet
Yes, yes.
of the two candidates because there is only two applicants.
Yes,
petitioner
my
and
lord.
my client.
It would be better, my lord.
No, no, আমাদের কাছে তো।
Nothing more or less, man.
In this route, two offer letters have been granted.
Only one, man.
আমি চাই না।
36.
One vacancy, two
30,
applicants.
35 and 36.
Was
Oh,
rejected.
there was only one vacancy.
Yes, yes.
Only one vacancy.
So please come back with these two documents.
Yes.
35 and 36 minus serial number. Petitioner
No, no,
is
different
Khurshida Begum and 36
Different.
Swapan Kumar Shah is the private respondent.
Who
Swapan
got
Kumar
the
Shah was approved
approved to
offer
issue
letter
offer letter?
and Khurshida Begum was rejected.
So let us see the documents pertaining to these two
No, no, no.
persons.
Resolution number same.
Mr. Naik,
My
please
lord.
come back with the report annexing all the relevant documents pertaining to 35 and 36.
Agenda number 8.
That should
Okay, agenda
suffice.
different.
Not all
Okay,
the
agenda
42 candidates.
My lord.
35 and 36, all the documents.
Nothing
How
more.
you have considered.
I my lord, certainly. I bow down, my lord. What my lord desire questioning?
Come back with these documents. Please come with a report.
Agenda number 18, my lord, serial number 35.
35 and
18.
35 and 36.
35 and 36, yes.
Agenda number is 18. That is at page 20.
Petitioner is aggrieved by the resolution taken by the RTA board in a meeting held on 19th December 2023 with regard to
Agenda number 18.
item numbers 35 and 36, serial numbers, good, item numbers 35 and 36 of agenda 18.
Yes.
1-8. Stop. By the said resolution, comma, the application for issuance of permit submitted by the petitioner has been turned down on the ground that there is no vacancy in the route in question. So the application of the private respondent has been allowed. Paragraph learned counsel for the petitioner submits that his prayer has that the prayer of the petitioner has been turned down arbitrarily by the authority, though the petitioner possesses though the petitioner is better qualified than the private respondent. Paragraph. The state respondents are directed to submit a report in the form of affidavit annexing all relevant documents pertaining to consideration of the applications filed by the petitioner and the private respondent on the agenda. Paragraph, let the matter appear under the same heading on 6th May. 6th May.
6th May, Lordship. By using broadsheet.
One thing can I do? I can, my lord,
including the broadsheet.
Yes.
subject to my lord's kind permission, can I take this leave, my lord, to produce the original record before your lordship? Because, one second, if I file one affidavit, then some documents should be certainly, I will be according to my choice, or I will file. If I file the original record before lordship can consider that. That will be more relevant for them. My lord can also have, my lord, no question of, my lord, anything manufacturing. Your entire record will be before lordship. Lordship will see whether there is discrepancy or not. I can produce that.
I'll grant you liberty to file if you want to.
No, both or that, or either affidavit or, my lord, the original record.
No, it has to come by way of an affidavit. That has to be on record.
Broadsheet.
No, broadsheet, every record will contain everything.
Nothing more.
Why?
Yes.
Bring the Bandhamadhan Porvo, not necessary. Please bring the relevant documents with regard to these two agendas.
I will.
These two serial numbers.
I will. Accordingly, in my understanding, my lord, better enter record before lordship. Finish.
Entire record pertaining
Yes, file.
to these two persons.
Yes,
Not
obviously.
42 persons.
No, obviously. No, these two persons. These two persons.
But in the resolution.
Or, my lord, the original.
On prayer of the respondents, liberty is granted to produce the entire record concerning
My lord, in the resolution, it has been stated that the offer letter in favor of 19 applicants on the basis of broadsheet. Yes.
Exception. No. Since there are also a lot of questions are coming, I will file affidavit.
with using all the my lord relevant documents.
Advance copy maybe.
Including the broadsheet.
My lord, advance copy, my lord.
Yes, please serve an advance copy.
My lord, instead of fifth, my lord, instead of fifth, can it be six? Date to dekho bolo. Instead of six, my lord, perhaps that is the monthly list may come out. Seventh.
Seventh, right. You're right. Thank you.
Yes.
Seventh.
My lord, in the next matter, the petitioner does not want to proceed in this matter.
Not want to proceed.
Yes. My lord.
For the
Do not want to.
Instructions.
Yes. My lord, written instruction is there.
Learned counsel for the petitioner submits that the petitioner does not intend to proceed with the matter any further. Written instructions submitted by the petitioner is taken on record. Didi, instructions.
Affidavit of sir.
সুভাষ তো কোনো উইথড্র করে না ফাইট করে But I appear for the state.
Paragraph in view of the above, the writ petition being WPS such and such is dismissed for non-prosecution. Paragraph, there shall however be no notice to costs as in certified petition.
That's yeah, one
This is affidavit of service. This is not the instruction.
Lord, earlier, my lord, I have given
Oh, this is the
written instructions.
next.
I am appealing for the private respondent.
Your names.
My lord, private respondent, sir. Sir, copy. My lord, earlier occasion, my lord was pleased.
You are appealing for the state
My lord,
private respondent.
my lord, on similar route, same resolution, earlier order was passed, my lord, by setting aside the resolution and my lord, remand back the matter to the transport authority. Same route, same resolution. May I hand over? আর কপি নেই আমার কাছে আছে হ্যাঁ না না ঠিক আমি পরে দিচ্ছি তুমি এজেন্ডা নাম্বার 16 serial number 12 same route same date of resolution page 33 and 34
Serial 12.
No reason assigned.
no
No. Well, I have seen there is no reason assigned.
A resolution my lord below in favor of Sarojit Bhaumik and Amarjit
Agenda number 16, serial number 12.
12
12.
Priti Banerjee.
Priti Banerjee. But a resolution, bottom, in favor of Sarojit Bhaumik and Amarjit Prasad in the route 45, 45A and rejected other 3 applications as there are only 2 vacancies.
Let the same order be.
Yes,
Let it be reconsidered.
Yes.
এই একই order.
Same order হবে। শুধু এই যে এখানে
এটাই।
যেটা আছে agenda number 16 ঠিক আছে deals with route the same route 45
Same route.
I have seen.
But only because my lord, I have supplied this order.
so no change is required. That's
No
the same
change.
order. And it's the second respondent who will consider.
Yes, my lord. Regional Transport Authority.
Second respondent.
The same order. Huh? The second respondent.
Much of
The private respondents affidavit of service action. Same order. Identical.
এটা ওই যেটা দেখালাম
Next.
my lord. Here my lord, private respondents are there. My lord, I have served copy. My lord, an earlier broadsheet is required, my lord. Otherwise, my lord, it will not be.
The number of the serial numbers.
Affidavit of sir.
785 আপনি নিলেন তো সেম অর্ডার হবে খালি ওই এগুলো চেঞ্জ করে 785
Serial number is my lord 09 of petitioner and the grantee is 11. Serial number 11.
affidavit of service দিয়ে শুরু করবেন
Agenda number 780.
page
Page 27.
the serial number
09 is the petitioner and 11 is the grant, that is the private.
agenda number 8
কত সিরিয়াল নাম্বার কত 9 হচ্ছে 9 আর
serial number 09 হচ্ছে
and 11.
and 11
Yes. My lord, a preliminary report is with me, lordship, like earlier. Let me file that.
is it
my lord.
necessary
It's not,
because you'll come back on affidavit is it necessary
it's not required, but since my lord, I will.
next
Grateful, lordship. Same date, holo, same date.
789
My lord, the matter is from 7th, lordship.
same date yes
Same date, same date.
the date for returnable date is
Lord, in this matter, I'm appearing on behalf of the private.
My lord, it is also similar, my lord. Serial number 16, page 29. No vacancy, no vacancy rejected, and without broadsheet, my lord, the matter not be
But a
adjudicated.
resolution has been taken, that has been, decision has been taken in the broadsheet. Because
Let
when
the
the broadsheet, I
broadsheet
become
come
successful.
before
Yes, in the broadsheet, it
let
will
the
prove.
broadsheet
How
come
Yes, yes,
it becomes successful, it will improve in the broadsheet.
broadsheet.
I agree with.
where is the resolution
At my lord, page,
who is appearing for the
page
state
29. Page 29.
ওই broadsheet চাইছি
Petitioner page, serial number 16.
পুরো order same order
Petitioner serial number 16, my lord.
and the private respondent
17,
The private
17.
number,
One-
17. Next item 17.
70
16 and
17, my lord, I'm private. I become successful, approved police operator. Two vacancies.
no how many private respondents
17,
two private respondents,
17 and
21.
21.
এটা private
I
respondent
appear on behalf of 17.
17 and 21 are the
20
private respondents
Yes, yes.
serial numbers so 16 petitioner 17
আরে তারা তো আর আসেনি এখানে।
আলাদা বলি 16 17 and 21 তিনটে হবে আর the private respondents
Yes.
let the broadsheet come
One absent.
they should be yes all these records should be produced
All the candidates, but it only broadsheet, broadsheet for all the candidates of the route.
In the broadsheet, my lord, all the
report in the form of documents
all candidate decision recorded.
16 to 24. 6.
pertaining to the applications
16 to 24, man. Once
private respondents করুন এখানে and the private respondents as well as
16 to 24.
16 to 24.
কাজ করুন pertaining to petitioner pertaining to serial numbers
16 to 20. And 16 to 20.
Out of 24, my lord,
16 to 24
Yes, yes, yes.
pertaining to serial number 16 to 24
Yes. And all the matter will
matter is
appear
fixed on same date.
7th May, same day.
7 May. 7 May.
Next.
790 minute, I appear for the petitioner.
Well, I am for the respondent.
This is the copy of affidavit of service. Everyone has been served.
Is there any private respondent?
No. But in this matter,
Have you served copy? Mukerji?
Matter is appearing. No, it has not been served.
You received a copy of the intervention application? You've not served?
Just I file matter unless your lordship allow me, unless your lordship allow me to.
but it is not a supplementary affidavit, it's an intervening application. Application copy can be served after
No,
filing.
that if your lordship allow, then I shall serve matter. May I serve matter?
But kindly have a look at page 101.
I have to deal with the intervention application first, since he wants to be added as a party. Let there be a date. You have served an advance copy, Mr.
But
Mukherjee.
I have, I have,
Okay.
but now I am signing. Matter.
It has been
Henceforth,
served
matter,
earlier.
whenever I file an application for the addition of party intervention, I will.
Where is the application? It is not in the file.
But it's appearing in the list, your lordship.
Service. Along with them. WT along with them. Can 1 of 20. Service. Copy of the application being can 1 of 20 is made over to learned counsel for the petitioner in court this date. Paragraph, let the matter appear under the same heading. On 7th May, you don't want to use an affidavit against this, an opposition? No?
No. Will kindly give a short date. Short date, will kindly.
Well, subject to minor correction, if your lordship allow then will this petition, the locus standi of the petitioners, your lordship will find they are saying that they are dealer. I have got a copy of the writ petition, but through Sartha. There I found, they say that he is the dealer. Now, he is the dealer. In support of his claim, you should annex the document that we also will have under the motor vehicles, central motor vehicles rules. There is a provision that says, the dealer must have to be a certificate that called the trade certificate registration, TCR. That has to be annexed in their petition. Your lordship will not find. And your lordship, another, they are the dealer. They are asking for registration. Their original manufacturer, but who was a party in my suit, they have stated here the manufacturer has already written to the authority for taking necessary steps to register their. That has been who are they? How they are asking for registration? They are not the manufacturer. And each and every paragraph they have stated these are a different type of the battery.
But it's generally the prayer of the manufacturers.
Yes, they are not the manufacturers.
The manufacturers apply for registration of
and your lordship will
rickshaws.
As I know, your lordship will take up this writ petition. There are 3 writ petitions. All 3 writ petitions, they are the dealers. And they are the dealer, they must have to produce a document annexing that they are actually the dealer. That is under the central motor vehicles. That has not been here annexed.
You have not annexed the document.
But all the documents are annexed, Milord.
Whose document is the manufacturer document? But they are the dealer, they are saying.
The document authorizing you as a dealer. A dealer registration is required for being a dealer.
Milord, I have annexed all the documents. Milord, kindly. The trade certificate
authorizing you as a dealer. Please show me that document.
Milord, kindly comes to page 29. This is the trade certificate, which my learned friend is agitating at this moment. Page 29. First.
This is the trade certificate.
And my learned friend is telling that I don't have a.
So please come back. I'll deal with both together. I'll deal with
They are the dealer. Now they are the dealer. They
don't mislead the court, at least. With deepest of respect.
Please come back on 7th of May. Next.
Seventh May.
I'm appearing, my lord.
Here is also the same.
Item number 290 to 293 are same.
791.
790, sorry. 790 to 793 are analogous.
790 to 793.
Are analogous.
So that you are filing your applications in all these.
There is there. This appearing.
All these matters?
All three members.
I'm only a 90 and 91.
Same order.
Seven nine.
794.
See also, my lord. May I hand over?
793 of the same.
90, 91 and
90 to 93. 790 to 793, same order.
four matters.
I appear for the petition in 794, my lord. Here is my evidence service. But the matter relates to the under the exception clause. This matter covers but this matter covers under the exceptional clause of the notification regarding flying of the buses through Bardhaman town. Earlier all matters, your lordship has been pleased to pass an interim order permitting the petitioner to ply the vehicle on the basis of the permit now subsisting. The permit copy, Lord, page 16, page 17 is the permit. But it remained valid till 16th of November 2025. In the bottom, in the bottom marked portion, Lord.
Page?
Lord, page 17. Page 17, Lord.
I'm afraid you have to come back then tomorrow. There's a full court reference.
Similar matter, Lord, 6.9 similar matter.
Lord,
All types of Bardhaman.
And in all the matters, you have been pleased to pass an interim order permitting the petitioner to ply the vehicle.
Let it be just not today. I'll deal with it tomorrow.
Lord.
Let it only be not today. Please come back tomorrow.
Very well, Lord. But tomorrow, if for my personal reason I could not come, your lordship kindly give accommodation. If I could not come, very grateful. Thank you.